He is almost on the way, he says. Well, he's on the way, so he should be here.
MP Tamika Davis is going to be absent today.
All right. Thank you. So we note those. But we do have a quorum now, and I said Member of Parliament Sibley should be here any time. I'm hoping we can go as far as we can in this. We have reserved, what's the other date we have reserved? For Tuesday next week. And there's no Parliament next week, so reserved next week, Tuesday, and hope we can go through. What we have is a fully printed bill with the suggested, the agreed amendments. It is going to be displayed on screen. From the beginning, so we can follow through. It came in at that point in time that we go to the printing of copies. So can we begin the process? At the same time, I'd like to thank the Parliamentary Council, because we had to do this in quite a short time, and actually got the instructions and from the minutes of the meetings we had and all the suggested and proposed amendments and adjusted. So it's a big bill, and I've gone through all of it in the time with a lot of amendments. I want to thank her and her team for all the responsibility. I'm hoping we can really take it through to take the bill. We will prorogue on the 20, Mr. Million, your brain younger than mine, so we prorogue on the 24th fully, right? Yes, 26th of July. So we should be able to conclude our deliberation of this bill by then, I think. Go on recess. I was waiting on your response. You agree? We'll take the summer break, the 26th of July. There'll be no sitting next week and the other week. So we have a little space, but we should be able to bring it back by then. The process as it is, we should be able to bring it through. Ms. Grant, should be able to bring it through by that time, unless this team makes a lot of, give you some more trouble. All right. Okay, so we'll begin on page 1. I will start the ball rolling. Mr. Sinclair may have to help me roll it through, since you're very familiar with the bill. But page 1, we have the Any more hard copies? Yeah. Yes. Yes. Yeah. I'd love that, because then you could help me go through it. Right? I'll take it. Yeah. I'll go slowly. We're going to try and get a few more copies printed quickly. In the spare one on that side, Mr. Richards. Anita's going to try and get me some printed. So I'll start. Page 1, the title. The first change is in interpretation. Section 2, A is deleted. That is, acquire means to A. What was originally A, high, is deleted, and now B now becomes A. And the listing is suggested. Accept as a gift is the first item, and it continues to be A, B, C, D. And there is no E. The next change is in page 3, page 2C, no corrections.
Chair, I'm sorry, can you just go back to acquire 1 second, please?
Huh? Go ahead, CP. Acquire means to, you deleted A. That's it. Who came in? CP, you're saying something, CP? Oh. All right, the next major change continuing interpretation. After artillery, which means cannon, etc., assorted parts. Page 3, the top of page 3. That's where the next big change comes. These are I'm sorry, Richard, this is in red. This is a redefinition. This is new. Right, okay. All right. Let me read. Assorted part in relation to a firearm or prohibited weapon means any item that can be attached to a firearm or prohibited weapon that increases its usefulness or effectiveness, but which is not essential for the ordinary use of that firearm or prohibited weapon. Right, which is the thing like the 100 rounds magazine being acquired now, and, which makes far more. They are converting it from a semi-automatic to automatic, which is fairly easily done. Clips. That's nothing else on page 3. Page 4. Page 5, still under interpretation. And page 5, under firearm, A1 reads, means any barrel weapon which discharges or is designed to discharge any shot, bullet, or other projectile. Missile is removed. And 2, 3D printed or is deleted. No, and for that. Wait, hold on.
Yeah, Chair, so in keeping with the discussion that was had previously, the reference to 3D printing is removed to the end of the provision, and it has been broadened because the committee wanted.
Understood. So it's deleted here, but it's further on the comment.
But it's still at the end of the definition.
Detail is deleted as
at
2,
the end of paragraph A.
But it'll come later. At 2, it's deleted as A2.
And the purpose there is to broaden the reference because the committee wanted to leave the possibility open for more technologically neutral language.
We'll go there then, CP, and therefore 2 now becomes prohibited weapon unless the context otherwise requires.
Make available to members some personnel, some department to become familiar with the 3D technology that is being used. Sir Bernard? Okay.
I was absent.
May have been absent.
You are very reliable at that. I think it's the one meeting you're missing. Sir Bernard came and explained the 3D printing operation.
I know I had some traveling engagement during the program.
All right. So in this case now, 2 would continue, Ms. CP, prohibited weapon unless the context otherwise requires, and includes any such weapons created as 3D printed weapons or otherwise created through the use of electronic software or similar technology. So the 3D comes back now under 2, but after the term prohibited weapon unless the context otherwise requires, and includes. Okay?
Chair, before you move on from that one, can you just scroll up to 1 above, right? Okay, yeah, thank you.
Okay. You getting printed? All right, good. All right. Continuing under, we're still in interpretation, right? Down page 6, we get to under the section firearm and toolmaker definition, firearm and toolmaker examiner, toolmark examiner means a person who is experienced and competent in is kept, but B is the analysis of the sequence. That's an addition, right? Analysis of the sequence of events relating to a shooting incidents. Right? It's kind of forensics, okay? Nothing more on page 6, still in interpretation. Page 7, actually no changes. Page 8.
Actually, there's a change, Chairman.
The change on page 7?
Page 7, on the firearm shooting range.
Firearm disposal expert import firearm manufacturers. Firearm shooting range. Oh yes, sorry. Means a license authorizing the holder thereof to operate a firearm shooting range. Firearm shooting range means a facility specialized in remove. It means a facility operating pursuant to firearm shooting range license. So the word specialized is used. Specialized is deleted.
And we've also removed the word archery.
Remove the?
Archery.
And B, yes, the design for shooting practice for firearms of such type and at such place with the removal of the term archery. Continuing and interpretation. Thank you, Mr. Richards. They look at page 8. There are again small changes here. At the very beginning, firearm user's permit. No, there's no change there. Firearm user's license, I see 2 underlined here, means a license authorizing the holder to possess such firearms, such as added, or ammunition as is specified in the license. And then on the continuing on the firearm user's permit, which is page 8 still, means a permit authorizing an individual not younger than 12 years of age and not 21 years of age or older to possess and use a shotgun, air gun, or ammunition with permission of the principal holder of the firearm user's license. This is one of the recommended changes. That's correct. So it's age 12 and it's a shotgun or air gun. And the firearm user's permit, which allows for the training of the juniors. Page 9, another very short change I am seeing on the gunsmith license. That's the first change, Mr. Richard. Means a license authorizing the holder of 2, A, cell is removed, test, deactivate, modify, proof of any firearm or ammunition in accordance with Section 42. Mr. Richard, we have a license for gunsmith now.
We do.
Eh?
We do.
So I would lock down the man as a gunsmith. If the court decide that he's a gunsmith, you could just rearrest him at that point. Senator, and that's the gamble. The law. I mean, if a judge declares him a gunsmith and he doesn't have a license, then he's illegal. Mr. Jackson,
He's operating an illegal operation.
Yeah, but it's a crime to operate such an operation. And it is coming from the bench, so he's already guilty. Seems they have some special condition in St. Catherine. You know, we have to look at it again.
Just a Chair, just a quick clarification. The existing definition of gunsmith's license, there's an existing definition in the current Firearms Act, yes? No, yes?
Check on it. Send.
My indulgence a bit. I know we may have deliberated, but I'm just reflecting more on the deletion of cell. And at the surface of it, you know, I would say fine, but the thought came to my mind, in many other businesses, when clients, customers leave an article for repair or any service to be provided, and they take an undue time to come back to collect it, what recourse would the gunsmith possess to, because he would have extended time, expertise, and material in some case in providing the service. Normally people would sell the item, right? Is there a provision as to how these persons will be able to treat unclaimed items that are taken to them after some specified period of time? No, I'm not necessarily saying, but how?
Is there a provision for that, Alex? I wouldn't ask him to sell. I would restore that, Alex.
Yeah, I'm not.
No, I'm with you. I would expect there should be some
provision
to allow to hand it over to the FLA or to the police.
Right. I guess in a case like that, they could hand over or surrender the weapon to the FLA, and the FLA could auction. And there's a provision for auctioning at. Yes.
And the outstanding sum be settled with the person from whom it was taken. If the man... No, he's not auctioning, you know. He's a third party that is now auctioning. From the auction? Okay. To the consolidate or to the FLA. So is that so, Mr. Richards? Are you...
The auction provision is at 102. It's outlined at 102, and it states how the proceeds of the auction should go.
What section is that?
Firearm ammunition could be voluntarily surrendered to the authority, seized or recovered, or left in the custody of the authority beyond a specified time, transferred to the authority in certain circumstances. Therein the authority can auction, and then the proceeds shall go to the lawful owner and any other administrative expenses that the authority...
the lawful owner and the
any other administrative expenses that the authority would incur from the auctioning process.
Okay. Not looking at it, does it expressly make provision for such persons like the gunsmith who would have turned it over to the FLA because of non-claim?
As it is now, the provision doesn't speak explicitly about that, but I think it can probably intimate it. It's probably something that we can look back at in terms of how that can be appropriately captured.
I'll suggest that, Chairman. Since we're on it, make sure that we try and cover as much bases as is possible.
Same, page 10, have a few changes. On the imitation firearm, is capable of discharging a shot, bullet, or other projectile. The missile is removed and changed to projectile again. Okay, that's page 10. Near the top. And near the bottom, we have added a C to modification. Does not include the change in the choke on a shotgun, specifically. C, which is important. No, as well, A has means any act that results in a difference in the appearance, function, or performance. And C, it does not include changing the choke on the shotgun. We get that screen to have some bigger fonts, you know. Anyway, we're getting the hard copy of the way of it. And then parts and components means deleted any item that can be attached to a firearm, and any items or replacement items specifically designed for a firearm and essential to its operation, and includes a number of things that are listed on page 11. In that section, part of B is deleted, original B, and the part deemed essential for the function had already been said in the section, first sentence, and B now become, C becomes B, any part designed solely or exclusively for converting a semi-automatic to an automatic firearm. And C would now be any device designed or adapted to diminish the sound caused by a firearm, firing a firearm, which would be a silencer of some sort. But sometimes they make some artificial one. They put a plastic bottle. I give you all the time. So on page 10, C is put into X, states quite clearly does not include changing the choke on a shotgun. And then there's a change where any item that can be attached is deleted, but any items or replacement items specifically designed for a firearm and essential to its operation. B, that was there before, deleted, because that's covered in that statement I just read.
Chair, can I just ask, I'm trying to actually find the provision on modification. Which clause had dealt with the prohibition against modification?
So this is the interpretation.
39.
No, 39.
39. What really, where's the interpretation, Member Jackson? I think the Senator was asking for the actual bill. Yeah, the actual clause that deals with in the bill.
It didn't, I don't think it hit me on our first go around of this, but part of the definition of modification, including alteration and effecting repairs. If the repairs effected don't change the weapon in any way, is that what we're trying to capture? Or we're trying to capture a scenario where the weapon is altered so that it's different from what it was before, or enhanced, or something like that. But if I simply take a part and replace it, and the weapon is identical, have I modified the weapon? Is that what you're trying to capture, though? And if so, why?
So the idea is really for any kind of repairs or anything else that you're going to be doing to the firearm to be done by somebody who is licensed by the authority so to do. So the reason why we included or we excluded the issue of the change of the choke is because the firearms come, those shotguns come with kits which will allow the user to change the choke based on whatever activities it is that they're going to be doing. But anything else that you're doing with the firearm should really be done with authorization by a gunsmith who are licensed by the FLA to do that kind of modification.
I understand, Member Campbell's question. If you change a part on it, and parts may come with various designs, so you change a part for its functionality, but does not for the gun to function, but within the same realm that it originally was. It's not the same, but it doesn't change the functionality of the item. Is that considered modification? That's what I was understanding.
Still considered modification. The idea is that any modification to the firearm that you're licensed to carry should be done with the authorization of the authority.
No, maybe not, didn't make myself too clear. Say, for example, a nut. It might be a far-fetched.
Covers the critical thing for the shotgun, right? In other words, if you may have more than one type of choke, and I'm not familiar with all the details, but this is saying that if you back the sports shooter or the skeet who may wish to change the choke on the shotgun is not doing anything illegal or changing at home. That's because he's by them. They're standardized operations, as opposed to one who is converting the Glock to automatic with a little clip.
No,
That's
but
illegal.
the conversion is clear. I don't have any problem with the restriction and the converting. But what I was gathering from
modification.
Campbell's question for modification, if you change a part, no, I'm not no expert on guns to know all the working parts, but if you change a part, and she was saying, but it doesn't change the functionality, it's not the same, or the appearance, it doesn't change its original functionality, but it's not the same as the one that it replaces. Would that be considered a modification? That's the question.
Based on the definition, it would. And the idea still is that all of these changes, any repairs that you're effecting, should be approved by the authority.
Ultimately, you want oversight of all of that. I have no difficulty with that.
All right.
Okay.
All right. And note the changes now, and continuing on the same section for firearms, set it up on the ace of the next section. In the part deemed essential, that was covered in the last section, and the renaming of the section B and C. We go to page 12. Nothing new there. Page 13. Here we come now to the 3D printed firearm. There's a significant change. It says, means a barrel weapon which discharges or is designed to discharge any shot, bullet, or other missile, and that is mostly produced or manufactured with a 3D printer or any electronic software is added. That is to cover the possibility of software being designed to make parts or such a weapon in a newly designed printer or in a traditional printer. We'll discuss that.
Because it kind of mirrors the description of firearm, but in the description of firearm, didn't you change the word missile to projectile? And
Yeah,
we keep it as missile here? Or
A bullet is listed here, so
it says
you're
shot,
right.
but the firearm description of firearm says shot, bullet, or, and I think we changed the thing to projectile. And as I said, because it seems to mirror it, I'm just asking if it was an
it seems
oversight why
correct.
this was not also changed to projectile.
Yes, I think that was an oversight, I remember.
CPC.
That should be projectile.
I saw that. That's good. Any comment on that? I'm sorry. Looks reasonable. We're going to make that amendment as Mr. Richards. We'll make the amendment so that it has is
Yes,
consistent throughout.
I've
all
noted
right?
that.
All right, page 14. All right. At the very top, transferring, no, sorry. Read the whole sentence. Trafficking. traffic in relation to any firearm ammunition prohibited is at the bottom. I'm reading from bottom of 13 over to 14 because it continues. So, traffic in relation to firearm ammunition prohibited weapon or the categories of conventional arms means the import, export, transit, transshipment, brokering, acquisition, sale, delivery, movement, or transfer of the firearm ammunition. To page 14, prohibited weapon or other categories of conventional arms, whether within Jamaica or across Jamaica's border. Transferring includes, we delete A, letting on here, to A become giving, lending, or parting with possession. There's no A, B, C, there's no D. But the question of hiring comes elsewhere.
Right, so remember we had removed the definition of hire from acquire, so the policy was not, firearms will not be let on hire at all.
Okay. A firearm would not be available for hiring at all. I won't delay the bill, but we have discussed the possibility of the, what do you call them? It's essentially a imitation firearm that is used in, or non-lethal firearms, which are used in movies, which is posing a challenge to the movie industry. That the way to resolve it may be to allow somebody, a licensed gun dealer, to stockpile and hire when the movies require them, because it's a very tedious process to get them in there. And there's room for such an industry as there are increasing number of movies. And pretty much every movie requires, almost all the successful movies don't require. They still have lifestyle. But I wouldn't delay the bill. We have to look at this, though, because I think that is, it has been raised. We have had several movies recently in Jamaica, including James Bond, and it's a very tedious process to get in them, the firearms in. They have these, they build them, they're specially designed. They look perfectly like a weapon, but the projectile that they've dispensed is not lethal. But I said the bill now prevents hiring altogether, so I'll let it stay for now, and we'll look at it again.
Chairman, if I may, I fully support the point you made. And on one hand, on another hand, we have for some years now been promoting Jamaica as a film location and encouraging filmmakers to come to Jamaica. And to the extent that you have a functional impediment, like the one you make mention of, and since we are in the process of reviewing the pertinent legislation, I think it will only be in order that we seek to incorporate those identified impediments. A different thing that didn't come to light now, but to the extent that we have identified it, I think it would be an indictment on us if we saw it and left it, and then we create another problem elsewhere, given that we are a joined-up government, that we seek to deal with it. Even if it means a week more in delay, I think it would be worth the while.
Thank you, Member Jackson. I take your comment here, but the reason I didn't push is not only to speed up the delivery of the bill, but there are a number of other factors that need to be addressed. It's not just the firearms is one big one, but you know they have had to rebuild Port Royal somewhere in Puerto Rico, I think, because of this current regulation governing moving the movie scene out, in and out of the country. And I think in St. Lucia there is another replica of a part of Jamaica designed. And the Pirates of the Caribbean, which was surrounding the history of Port Royal, has all been filmed in Puerto Rico, Dominica, and St. Lucia. So there are a number of things to be dealt with, and as legislators we should bear it in mind and hope we can get it settled, because they have a hard time doing that. Just the fact that firearms was pointed out, I came across it because of the firearm issue, which we can try and which still comes through the ministry, but there are a number of other factors we may have to just have the Ministry of Industry, Commerce, and other ministries involved so to come together as a full program to review this. It is being marketed and it's proven to be a desirable site, but there are other things associated with it which has really gone. As I said, you know, rebuilding Port Royal in Puerto Rico is not exactly a credit to us. Right? Yeah. But there are a couple of people getting increasing inquiries, so we'll have to sort it out quickly. Page 15, no, much to it. Page 16. Come on. I see no changes. Page 17, weapon, possession of prohibited weapon. The very top. I missed one.
Not that you have missed. I think you have completed the interpretation section. Before we move away from it, I'm asking a question. We don't have the benefit of the actual amendment, the amended bill, right? So I ask it here. There was a discussion that was raised in relation to some definition of fit and proper. We had that discussion in the committee, and comments were made by Minister Malahoo Ford that it would be something that would be looked at. I don't know if it is addressed further on in the bill. It is or not?
The schedule on the schedule which on the third schedule of the bill actually outlines what are the fit and proper criteria. It was also in the original. It was in the draft bill that was discussed, but there were some tweaks that were made for the revised bill.
Sorry. So the original draft that we got of the bill, you are saying has it? Third schedule. Third schedule, what page is that, Mr. Richards? Okay.
Page 117.
117. No. In the first draft that we got? Because my 117 doesn't have that. Page 117.
Page 117 or section 117?
Section. Page 117 in the draft that I have refers to the second column, first column. Sorry? Page 87?
117 is of the enactment, page 87. Section 87.
The third schedule that I have is referring to the Board of Authority.
The fit and proper criteria outlined on page 88 of that draft which you would have. Paragraph 6. 6.2.
No, man. No. I'm not talking about membership on anything. I'm speaking about applicants. And it was a discussion that we had. I don't know if any meetings that I may have missed, anything else came up. But when I left from that committee meeting, there's a comment which was made by member Ford in respect to it being something that would be looked at. So I don't know if it is in the amended bill, whether it was considered or it was considered and not advanced. Now, because I don't see it in the interpretation, anything addressing it in the interpretation section, and not having the advantage of printed copy of the amended bill. Oh. 1 I'm not the answer. Whether it is in the amended bill, if it is not in the amended bill. Right. There are other legislation that we have, because I think in the discussion, the CEO of the FLA was somewhat against a definition being included. I don't know where we have come down from the point of view of the policymakers and so forth, but it is something that is of concern to persons who apply, and then they can't understand why it is that they are refused, and they don't know on what basis that they can advance their review when somebody just broadly tells you you're not a fit and proper person. Right? Other legislation defines the term fit and proper, and so persons can appreciate why it is that you may not be able to advance your position relative to that legislation. So is there any reason why we cannot include something like that? Is it that, why not? So, yeah.
All right, so if I may, so we did not include a definition for fit and proper, but we thought that the criteria outlined in clause 58, which speaks to how a firearm authorization should be granted, the type of person, so authorization should not be granted to a person below the age of 21, to any restricted person, to an applicant who the board has reasonable cause to believe is of intemperate habit, suffering from a mental disorder, has a history of mental illness, drug or substance abuse, domestic violence, and so on. And we included the provision about the applicant undergoing psychometric testing as requirements for determining whether the grant of authorization can happen. So there are several criteria that we thought that was good enough to kind of capture the whole issue of fit and proper. I think defining fit and proper in and of itself for the applicant is kind of limiting the authority granted to the board to make that discretion as to whether or not an applicant is fit and proper.
I share Member Sinclair's perhaps concern, which is, and because many of us would have gotten reports of persons who have been denied and they don't know why, or the authority just say it's not approved and you're not qualified, and no set of, for these reasons that we are denying you. I too would share that concern, because at the end of the day, the ordinary citizen who applies for this permit or any such thing that the government have authority over, if you are denied, it should be very clear why you are denied, and it's for objective reasons rather than some unknown reasons. I know of cases of persons who have come to me and I made inquiry on the FLA, and they never tell them why, but they have some other reason, but they're not disclosing it. And so the person leave aggrieved because they have been denied of a benefit, a privilege, whatever you want to call it, for a permit. And I think Member Sinclair's question is to make that a bit more transparent, the reasons why, so that the person who is denied can go away feeling satisfied. Why they are not. Though they are disappointed that they didn't get it, but they don't feel an injustice against them. I think that is the ill that they're trying to cure. So when the denial is made, that the authority state explicitly, these are the reasons. Having stated explicitly what qualifies you, if you did, because I might feel I qualify all of these that you set out, but you didn't give me the permit. Then why didn't you give me the permit? Because I believe, no, it is this one or that one or that one that you failed on. Yeah, that's kind of vague. Yeah, otherwise unfit. Yeah, that's kind of vague. And the only person who knows the otherwise is the authority.
And with this discussion field where there was a pretty extensive discussion, and at one stage it was suggested they should, if it's intelligence, they should go and get a, there's some discussion on how they would derive that kind of information without reaching the intel report. But I know it's quite an extensive discussion on this particular idea.
Yeah,
it came under this section.
But some, my concern is the chairman.
Yeah,
the ordinary Jamaican must feel that even if they don't get what they want, the state is not unfair or unjust to them.
No, I'm with you on that, but a lot of in fact, the biggest excuse what I find in terms of the FLA response is that they did not prove they need a firearm. It's not a right, but if the man has a business and fulfills all of the requirements here, I don't see a reason why. No, when they're unfit, there has to be some valid reason. I think if I recall the argument, was that they would then, if they are declared unfit, they have the right to get the information. They'll have to get a lawyer to write for it. They have to seek legal representation to get that, but the law will be entitled to get the reason. No, as I'm saying, that I think what we had said here, when the discussion was done, is that this would have to be part of it, the law. Not proving, not having needs for it is a bit nebulous. and here where they have flexible, no. How do you structure it? I need to be advised here. There was an agreement that if it's a valid unfit, we should only come from intelligence report based on a background of some criminality or something. And they don't want to declare the source openly. The person still has the right to be aware and made sure that they saw of whether the root cause of their.
That's very serious, Chairman. Because if I am a citizen and I am not aware of anything, or in my mind there's nothing that I have done that would make me unworthy to get.
I
know what is in your mind, but you won't utter it, and I won't say it either. All right? We leave it there. No, we won't.
I have several examples.
Yeah, no, we won't pursue that. It will remain in your mind and in my mind.
But I think already,
You see the point I'm going at?
The number one was all his mother's best son. Right? No, I understand.
But the objection.
I would suggest, member and senator, since 58 it was dealing with the issue of a condition appropriate to grant or not grant. When we get to it, let's give that a little bit more thought on it. By the time we get there, we will have some discussion.
Because I must tell you, Chairman, there's one particular person who I've spoken to who has been denied by the FLA. And they hear and they feel that they were unjustly treated by the FLA. And they hear that the Parliament is going through a review of the legislation that deals with the granting of firearm license. They are looking forward to the law being improved so that there can be some quote-unquote justice to them. And if we leave it after this extensive exercise, and a whole lot of people remain in the same situation, then we would not have done much to cure an ill that prevails.
Yeah, my sympathy there. I said, let's discuss when we get here, because now that we have in fact identified prohibited versus legitimate weapons, there is room to have the kind of flexibility in that section. So, yeah, let us do it there. So we'll continue. Objects of the bill we read through. There is no correction. This page 15, page Prohibition in respect of firearms and ammunition, section 5, page 16. I had no changes in that section. Page 17, weapon, very top of the section. Trafficking in prohibited weapons, 2. We see a person, let me read the whole thing to keep it in context. A A person who contravenes subsection 1 commits a felony and shall, on conviction therefore, before a circuit court, be sentenced to imprisonment for life, notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole. Upon sentencing a person convicted for a felony under this subsection of the court, the court shall specify the terms of imprisonment, being a term of not less than 20 years. I remember the change was suggested here, that the person shall serve before, so you delete 15, it's 20, and delete the person be considered to be, it just shall serve 20 years that the person shall serve before being eligible for parole. Okay? I think that was discussed and agreed to. And you know, it's interesting. Well, no, we won't put that in the margins. We won't put that in the margins, but the most, not from a legal point, I think so the Privy Council is still our final court, just what it is. Because I say, Senator, confirm mandatory life sentence in a very nearby jurisdiction in the Caribbean. Yeah, we did. You're reminding that you had a long discussion. It went on. Thank you, member. You're always faithful to your comments. And possession of prohibited weapon with intent to traffic, 8, section 2 at the end. Again, imprisonment for not less than 20 years that the person shall serve before being eligible for parole. Those changes were accepted. Similar in section 9, manufacture of prohibited weapon or possession of device, therefore, again, the term remains at 20 years before the person is eligible for parole. Then section 9.2.3, page 18. Here are further amendments. No person shall possess a digital blueprint of a prohibited weapon, which renders the software for such a weapon a crime, or B, a digital blueprint of any, remove other, and have device with intent to manufacture a 3D printed firearm that is a prohibited weapon. Do you still need that's a prohibited weapon? A 3D under section you need to emphasize that. It would make a difference. But those were some of the changes for 3D firearm.
Can I don't know if we had ever discussed it, but I just want to raise a question. A homemade firearm, which is probably a less effective, if I could use it for what I want to say, type of weapon, versus an M16 or a fully automatic weapon. And is there any consideration to
should we
graduated minimums? You wouldn't go that way, Mr. Richards?
I frankly wouldn't, sir.
Pardon me?
I frankly would not.
I didn't hear it.
I frankly would not.
You would not?
I would not. I would not make that distinction.
No, you would not make that decision, or you would not
that
recommend
distinction.
that? You would not make that distinction?
Right.
Okay.
All right.
I'll be guided by your experience.
Of interest, relevant discussion. No, these days we don't find any of them. It's hard to become valid. All right. Continuing, page 19, prohibition and diversion is where the next addition comes. Section 12, prohibition and diversion. No person in Jamaica and no Jamaican citizen outside of Jamaica shall, in furtherance of a criminal purpose, be involved whether directly or indirectly, in any activity that results in the movement of any firearms. In furtherance of criminal purposes put in there. Sounds reasonable, but can the lawyer prove or disprove that the illegal trafficker was intent on criminal purpose? Because there seems to be prohibition and diversion. If this make a difference between a man who really has a block of illegal weapon, well, it's in a different section. Yeah. Lord will play with the language. I won't. It's an addition, Senator, to prohibition and diversion in section 12. That's the only change. And page 12, 20 has a significant addition. This is now section prohibition alteration of ballistic. Section 13, prohibition alteration of ballistics, reads 13.1, no person shall do anything to a firearm which alters the ballistic signature, and continuing, that's A. Then part 2, B, has some significant changes. It's a new, yeah, new. It's a new tree. It's trees added there, but there's a correction in section 2B. Imprisonment of not less than 20 years, 15 is deleted. Then added is 3. No person shall possess any assaulted part of a prohibited weapon or without the appropriate firearm authorization possess any assaulted part for a firearm. 4 is added as well. A person who contravenes subsection 3 commits an offense and shall be liable on conviction, therefore, before a parish court to a fine not exceeding $1 million or to imprisonment for a term not exceeding 1 year. Okay. 14.
Sorry, Chairman, before you proceed, this is really, I guess this is really drafting and how the drafter would have placed this provision. We were wondering whether or not this is the best placement, considering the penalty associated with this, which is assorted parts. If we're going by the strict rule of parts 2 being the stiffer part of the bill, I don't know if Ms. Grant, if this would be better placed under 45, which is unauthorized possession. I'm not a drafter, but I'm just wondering what you think in terms of placement.
This offense relates to a prohibited weapon, so it belongs in a prohibition regime, would it not?
Well, it really relates to, the asserted parts is really in relation to both the prohibited weapon as well as the firearm that you can get authorization for. So, unless, I'm not sure, well, I probably have to look at it a little bit more.
You had put a single penalty here. Is it that you want to separate the penalty for the possessing of the assorted part for a prohibited weapon from the possession of an assorted part for a firearm that is not a prohibited weapon? In which case, the last part of 3 could be moved over to a different section, but you would need to then specify what the penalty in 4 should be for the assorted part for a prohibited weapon.
Let me think about it some more, Ms. Grant. I think an assorted part for a prohibited weapon can also be the same assorted part for a regular firearm. So we may run into some difficulty in trying to make the distinction between whether the assorted part is for the prohibited weapon or for a regular firearm. So Sorry, I just need to think a little bit more. And I'll,
Yeah, suggesting that the section in 45 would be different from, would cover everything.
I'm actually suggesting, Minister, that I just get a little more time with the team to look back at this.
I detect in the draft that's coming,
Yes.
a desirable outcome, but I don't know if we can separate that. I'm not sure. What you're saying, it's difficult to separate them.
No, it's not a separation that's the issue. For me, it's how we capture the issue of the assorted part.
No, I hear you. So,
Right.
in other words, the schoolboy who is given
That would be a component part.
part of a firearm to take to
So
another
that would have put
gangster in the
15
community,
year bracket. But I don't think
as opposed to the licensed firearm holder who gives his son the shotgun, what they call it, kept to take to his friend. The two things, there's a difference, but in fact, in terms of how there's a difference. In other words, we just said we allow them to change a shotgun, the choke, which is part of the weapon.
Chair.
So John taking it from his father to his uncle, not yet licensed, would be in possession of a part. It has to be treated separately, but I don't know how you do it from the man who is the gangster who is taking it.
But Chair, if I might, just as a matter of policy, because if the same assorted part can be used in a firearm that is not a prohibited weapon, but it can be used as part of a prohibited weapon, maybe as a matter of policy you would want to treat with it in the prohibited regime, because then you would have maybe an undesirable outcome where somebody would then claim in order to fall within the lower penalty regime that the assorted part was in their possession for use in a firearm as opposed to a prohibited weapon, when that might not have been the case.
I'm inclined to agree with Mr. Grant there, because I think what the person that approves is that the firearm is a legitimate, that the part they have is for a licensed firearm, which is very different from the man who cannot prove, it would be, I guess, default, he said, possession. But you have raised it, think it through what it's, I think we do need some difference there. In other words, I am taking a part to a licensed firearm holder, one licensed firearm holder to another, as opposed to somebody walking around with the parts to go fix his gun in the gang. Tricky. 21.
Sorry.
Yes. Senator, go ahead.
You have the assorted parts as being. You gave an example of one licensed firearm holder carrying a part to another.
As opposed to a gangster carrying a part to fix his gun. It's trying to, I think, my impression is that the drafter is trying to separate the two in law.
But assorted parts probably would, Mr. Richards, a telescope, what do you call it, the telescope,
right,
for example,
telescope,
would be an
the
assorted part.
The grip sleeve, the sight,
Yes.
the laser lights, those are assorted parts.
Right.
Tripods.
Right.
Right.
Now, those are still parts that can be dealt with by persons who are in the underworld, right? The penalty there just seems a little on the low side to me.
Yeah, if you make a difference, I said, I saw that as well. We have to make a difference between the legitimate firearm holder and the illegal and the prohibited weapon.
Yes, but why would a person who has a legitimate firearm, he has then assorted parts? For what?
And
You have dealt with, yes. But then a person who has a licensed firearm.
No, not many, but I like, for example, the night sights, which you know on the firearm. One has the midline, and it just has a simple thing you put at the back of the pistol, which give you, it doesn't carry a laser, but it's also improve your aim at night. Which
All
means
right.
the two dots on the side rather than one in the middle.
But if that person wishes to attach that to their licensed firearm,
Yeah.
couldn't they go to the appropriate person for that to be done?
They're
And so he
supposed to.
keeps himself within what the law requires and does that modification. Is it that I just get the impression from your comments, Chairman, that you are saying that, well, for not a person in that category, license, has it, well, you know, you're trying to provide some protection for them, but they can be protected if they do the thing in the appropriate way. And so, if you find somebody seeking to acquire, have, and to...
So the parts that improve the weapon's potency.
Yes, but you would want, wouldn't you want some significant controls for that?
Yeah,
Type
this
of
is,
scenario.
I'm agree, you know, if we can separate them clearly, the man with the prohibited weapon, parts of a prohibited weapon, should be given a significant sentence.
But I don't see why you're going to make that distinction. Just make it and increase the penalty.
Yeah.
You have assorted parts. You don't want persons to just be in possession of these assorted parts.
In the other part, in the law actually covers the parts they can have legally, actually, like the choke on a shotgun, and the rest of the chain they have to go to a gunsmith, a licensed gunsmith.
Yes.
So this part really, literally anybody with assorted parts who don't have a license is in the prohibited section.
Yes, I think that, but then, and if it
So
is in the prohibited section,
So this is valid. All you have to do is increase the sentence for him.
even if you're going to keep it in the parish code, $1 million and 1 year kind of sound a little.
You can't get less than 3 years,
Well,
even in parish
But
court.
may I do, Minister, because take, for example, a grip sleeve. A grip sleeve is something that, as a firearm holder, you can...
A what?
Well, as a firearm holder, license holder, you can go to some other jurisdiction that is a little more liberal than Jamaica and get a grip sleeve for your firearm and go and you can bring the grip sleeve in
No, but
without a
then-
permit. Oh, hold on. You should have a permit, but you can.
Yeah,
well,
because-
you know how things go. And
No, we can't.
and
He's supposed to get a permit in the
supposed
past
to
for
get
firearm coming
right,
in.
because he's supposed to get the permit
Come to
either
your-
from the FLA or the Ministry of National Security.
Right. And then he takes it to his gunsmith to fix it.
Right. So we're saying that we want to, if that person is held in possession with that grip sleeve,
Nobody would have had the permit to bring it in. So he keeps, but he cannot keep it around for a year. But he had the permit. Takes
all right.
it to
So
a-
3
takes it to
million
a
in 3
gunsmith,
years.
So he'd have the guy there. Once he gets the permit, to make the change, he goes to a legitimate gunsmith. So anybody with a whole heap of parts is not up to this thing, or what the judge said, free contract. He's illegal, he must stay in jail. No, I think you could put a minimum of $1 million is the bit. Start designate these things in US dollars, you know. You must pay what is the maximum? $5 million? You should pay $3 million after 3 years.
Smith, the gunsmith in St. Catherine, you know,
Free agent.
could have a lot of assorted parts.
All kind of it's licensed by Mr. Jackson.
Mr. Chairman, pardon my indulgence, but I was on a little sidebar with my colleague here was to get a little clarification. The gun sleeve is the one on the handle? What part was describing? Gun sleeve. That adjusts the grip on the handle?
That's one of them, yeah. That's a part. Yeah.
But I'm told that those, just so I'm on the right page, the description, gun sleeve.
The
gun
gun
sleeve,
change the appearance. And we have the legal
appearance.
Yeah, change
Is
the
it the
significance.
one part on the handle? Grip sleeve. My understanding is that firearms purchased anew, they come with extra sleeves that you can adjust for your hand grip. Am I talking about the same thing?
That is correct, but you would have, this would have been approved by the authority when you're granted your firearm authorization. So the firearm authorization would...
So the firearm that have been approved by the FLA, and it comes with that as an extra, it is considered to have been approved.
The authority would have granted authorization for that.
Or to have?
Would have.
Would have?
Yes.
Is that implicit or is it
No. Remember, you have to get a permit to buy the gun, you know. And that
fine.
And it
the
describes
permit
the gun
was
you're buying.
granted for the purchase of the gun. And then those come with the gun at the point of purchase. So I was asking if that permit, which is required, given that it came with the gun, is the permit, which was approved by the FLA, is that permit then implicit?
Also state the assorted parts that are with the firearm.
Sorry?
It would also state the assorted parts that are with the firearm.
Okay.
In other words, the vehicle model you buy has sunroof versus the one without sunroof.
No, from Mr. Richard's description, you know, the sunroof with the car with or without a sunroof is fixed. The sunroof is there, and without it, it's not there. Is not any action that the buyer would have taken upon making purchase. In other words, I'm not cut out the roof.
When you get your permit, it will tell you that it is a Beretta XY and a Beretta of that tail come with the extra hand grips.
Okay.
Right.
Just wanted the clarification. Thanks.
All right.
So, sorry, Chairman, just
21.
Sorry, Chairman, just to confirm, we're moving the penalty to $3 million, 3 years?
Yes.
Okay.
Senator, three is reasonable. Too small still, you know, at the rate of going. We are allowed to change monetary fines by virtue of affirmative resolution, Mr. Richards. All right. So we can make that easy change there.
I just have to remind myself of some of the
legal, it must
the
be
fines
more
that we did in the parish court. The fines that we did in the parish court, 5 million. And so just to maintain some consistency, I would stick with the 5 million and similar. No, how many years? Yeah, 3, 5, went up to 5 years? Pardon me? 5 and 5?
5 million, 5 years.
I think we should maintain some consistency with some of the other penalties that we have in the parish court, even in relation to persons who are in the legal category who may have committed some breaches.
You know, once you're in the legal category, you're supposed to have a different regime. So if anything you make that low, when we get to it, we have to lower them.
No, it's just because I think the parish.
No, I'm agreeing with you now, that even the parish court, but the penalty for the man who has the prohibited weapon must be more severe than the man with the legitimate weapon. Otherwise, it'll be inconsistent.
Just that this offense seemed to have been one that was basically kept in the, well, it specifies the parish court as the court, with the jurisdiction in this matter. So I just like to see legislation done in a fairly consistent way. So 5 and 5.
Well, I'm searchers to give the CPC. Senator is suggesting 5 and 5, which means that you remain. The minimum is the maximum of the parish court, essentially. Page 21, first schedule. I don't see any amendment. Yes, first schedule. 4, a person who commits a felony. Again, this is a movement to 20 years instead of 15. Not less than 20, not more than 25. That's part 4. I think Mr. Jackson will find a space in South St. Catherine for the for prisoners, for these characters. I welcome the prisoners. Page 22, removal, alteration, mark, see no change, transfer, violation. On page 23, offense of seeking benefit through possession, through professing to have or to have access to a firearm. It's part of the extortion system. A person shall not, in order to gain an unlawful benefit, and added is or cause apprehension to any person profess to have or have access to a firearm. So added there is cause apprehension to any person. I like it, but how do you get that defined in law? How do you make a person apprehensive? I like the expression, and I don't trouble it, but it just, I can see some arguments around that. Page 24. Part 3. Now we are moving from prohibited weapon, right? So it says, power of the minister to declare firearms amnesty. This is just for the beginning of the operation. So we are moving to a section now to deal with licensed firearm holders and the operation of the Firearm Licensing Authority.
Pardon my indulgence here, Chairman. Section 4. And maybe the lawyers, but all lawyers over there.
Section 4 of?
I just reading over the section where it is, it shall be a defense.
Shall be?
Yeah, I mean 5. It shall be a defense to a charge for a felony under subsection 3 for the person charged to show that that person was at the relevant time in possession of the firearm or imitation firearm for a lawful purpose. So what I'm understanding here is that you go before the court if you can show.
No, I missed what section?
Page 21, sorry.
Page
5.
21.
14.
First schedule.
Yes.
14.
4.
5.
5. It shall be a defense to a charge
Yes.
for a felony under subsection 3.
Yeah,
For the
I'm
person charged to
understanding.
show that the person was at the relevant time in possession of a firearm or imitation for a lawful purpose.
It's saying that it shall be a defense. Shall, not may. Shall be a defense if you can show that it is for imitation, possession of firearm or imitation for a lawful purpose. So the person would have been charged and taken through the court and all that obtains in that process. Why establishing that to the police would not be a basis for him not to be charged? Because you are then subjected, the thing is a defense. And the same way that you can show the police that it was, you would show the court. Is it because the police didn't believe you why you end up being charged and you have it as a defense in court? The purpose of my concern, or the basis of my concern, Chairman, is that the ordinary citizen who is innocent by virtue of the fact that this was for lawful purpose is now dragged through the court, incur legal expense, incur the humiliation of being charged and jailed and all of that, when on the surface of it, it is a defense. It is a defense. I don't see any different than
I don't know, Minister, you are removing the discretion from the police, which is once the person has possession, is not a bad thing.
The problem I have with the 5, the problem I have with subsection 5 is this. The mere possession of an imitation firearm is not an offense. Correct, Mr. Richards? It is, if you take the imitation firearm and you use it in the commission of a felony, that makes it an offense. So what is the relevance of subsection 5?
No, the imitation firearm before could come in, for example, my next one, a movie set,
Yeah.
comes off with what is essentially imitation firearm.
Yes.
and say stick it up. The policeman locked him up threatening that offender.
No, if he comes off the set and says to someone who is not a part of the set, stick it up, isn't he then well?
But he was in possession of it for a lawful purpose. So he would have less penalty.
No,
it wasn't a prohibited weapon.
No.
He was in possession of it.
If he uses it outside of the set and says to someone, stick it up, for whatever reason, stick it up, I want your wallet, give me a wallet, stick it up. He has committed an offense.
Yeah, but what I'm saying, he would not be treated in the same light as a prohibited use of a prohibited weapon, because he acquired it lawfully.
So you're saying, if he acquired it, because he acquired it lawfully, he can go outside of the set and say, stick it up, give me a wallet, and then...
No, he has to be charged, but he would be treated, he would be given 15 years.
It shall be a defense to a charge of felony under subsection 3 for the person to show
He'll maybe find
that
some
that
money.
person was at the relevant time in possession of the firearm or
Anyway,
imitation for a lawful purpose.
What was the intention of this, Mr. Richard? I interpret it that way. Let me hear what... Section 3, which you are referring, is a person who at the time of committing or at the time when that person is apprehended for any offense specified in the first schedule has in the person's possession a firearm or imitation firearm commits a felony. It does say no person shall or attempt to use a firearm or imitation firearm with intent of commit or to aid the commission of a felony.
Right.
Or to resist or prevent the lawful apprehension or detention of himself or someone else. In other words, him can't use somebody who is doing that, to use a firearm to resist, arrest, or attack somebody or hold up somebody, is a felon, which comes under the prohibited section. A person who contravenes subsection commits a felony. Then 3, at the time of committing or at the time when the person is apprehended, has in his possession the imitation or the real firearm. And the person who commits a felony under that section is liable to a conviction before a circuit court, no fine, for imprisonment for such term of not less than 20 years. So what 5 is given is an outlet, that if the man come off the movie set, even though he's acquired legally, he would not be given 20 years. He would have discretion.
I don't think that is what it is saying, Minister. I don't think that's what it's saying. I think it is more applicable to, if it is restricted to 3, it is really 3B. So if I were to look at, let us say that he has an imitation firearm, and while he's in possession of the imitation firearm, he commits an offense under the first schedule, which includes cultivating, selling, or dealing in and transporting cocaine. So he has it in his possession, the imitation firearm. He's not using it, but he is found in possession of cocaine, trafficking cocaine. Then he's saying, no, but guess what? The firearm is really, I had the firearm for the purpose, for a lawful purpose. And I did not use it, but he's apprehended. Huh? No, he comes off the set. He comes off the set, and he goes to his second job, which is to transport the cocaine.
No, then once you have the cocaine, I'm in problems. Okay,
but then this is what is giving him a defense.
No, so you'd have to...
Sure, it would be a defense to the charge of the felony under 3B, but it wouldn't be a defense to the charge for the offense under the first schedule, which is a separate...
I think you need something. They take a homeowner that a licensed firearm. His son doesn't have a license or a permit, but someone break in the house, and the son... Father, but the son knows where the firearm is and get to the firearm first, to protect the family. And he used it. He wouldn't treat it as a prohibited weapon. And that this, he could be charged when the police come and find him with a gun in his hand. But you couldn't charge him. You wouldn't want to charge him under the prohibited weapon section. But what he would do was lawful. It was self-defense. There has to be an out. I'm open to discussion now, but there has to be an out for that kind of event. Although it can be used as well, abused. But that's the kind of thing I could see happening, you know.
I have a difficulty when the state recognizes that something in the substance of it is not an offense to the extent that you make it a defense.
No, but it's not the same way I said, the substance that the state makes it not offense. You know. What is allowing is the incident really that can in fact damage the use of this whole law, where somebody who is doing something justifiable, but in a manner that was not within the licensing regime, can be sent to prison for 20 years. And once we do that, everybody jumps at us for how we have structured the law. So as I said, he was a licensed firearm holder. You and your son traveling, come under attack. The gun is in your possession. You're hit, the son grab the gun from you, jump out the vehicle or wherever he is, shoot the man them. When the police come, your son is in the legal possession of the firearm. But what he was doing was quite lawfully. It's self-defense. Himself and his family.
Would they and help me your technicians of the law?
So he can plead guilty and be sent home.
No.
As judges now do with people with the prohibited weapon. Unfortunately.
No. Use the scenario you just gave, Minister. That somebody who comes
the police who do
in possession of a gun.
And the police could use discretion, you know, and say not charging you because the law is there.
No, you see the thing about it, I want to cut down the angle of the discretion to the police. Because discretion can
that's
be
what
misused,
this does.
you know.
By the law.
I want to follow up on your example. Because I accept the merit of your argument.
Right.
That a father and a son, or a wife and husband traveling together or in the house together. There's a shooting that took place, that is taking place. The husband, who is the licensed firearm holder, gets injured, unable to use his own firearm in further protection of himself and his household. His wife or his son gets possession of it, shoots an intruder.
Yes.
Right? In the circumstance, is there a breach to the wife or the son in those circumstances?
There's a breach, but the law, this clause covers him. This law gives him, the policeman, the difference. But if him go to court and plead, yes, it was so, and I was doing something lawful, and he's cool, it's a defense.
So
that's
he pleads guilty to the son or the wife pleads guilty to the possession.
This is what I see it as. If I'm wrong, am I right?
I know. I'm walking slowly.
Yes.
Because the ordinary person out there going to be trying to. So the son or the wife, right?
He would have had it illegally because he didn't have the license.
Fine. But in the circumstance of the use of the possession of it, and the wife or husband came into possession out of the circumstance that prevailed.
Right.
My question is, does the possession in those circumstances negates an offense of a breach?
It's an offense, but this law prevents him from being subject to the restriction placed here to being charged with a felony.
You see the thing about it is a chairman that bothers my mind. That wife or that son or daughter, or even friend, say someone visiting in the household, and the same scenario obtains. My difficulty is that I don't think in circumstances like those, a verdict of guilt, right? He said, I'm guilty, should prevail on such persons that they now have to, well, when you go to court and you...
But the law gives them a clear out, so I don't know, you have to treat guilt...
So you kind of just dismiss that guilt? No, I took the gun
Yes.
My colleague and myself in the same. I took.
No,
he
we
got
hear it
shot.
out. But what is it? No, I'm trying to get your. And we both are common ground, you know. But I'm trying to. Is the law permits? What he says then? He could be. Go to court, please guilty, and he's given no fine or any, no fine or sentencing, but he still has a guilty plea on his record.
Ah, that is the injury that concerns me.
Does this law
that
prevent
person
that?
now have on his record that guilt, on his record guilty of possession. So when him get a police record,
But it's not,
they go and show that
it is
him
not
is
an unlawful
guilty.
position. It wouldn't go in his records if it's not unlawful position. This says it's not unlawful. This clause now prevents him from being charged with unlawful possession. Lawyers, I have 4 distinguished lawyers here. Tell me.
You know,
and the technical team.
I think where you created a little confusion for me is when you say the person come off the set and say stick it up.
The person
But
what?
When you use the example,
Yeah.
and the person came off the set and said to someone, stick it up.
Right.
That was a bad example.
I agree. That's a bad example.
The
The
other
wife and
one-
husband and the brother, so they're different. Is a better example.
Yes, which I think is what you're seeking to capture in fire.
Yeah, this is what
Okay.
I would expect Miss Legal Reform Interpretation. Does this cover that? And if the person is, this prevents him from being charged with illegal possession, I'd expect. Am I right? No, it kind of sounds like, I said, I'm interpreting, it's very common sense. It said, if the person,
It does. It says, yes, Chair. It says at the time, the relevant time, they were in possession of the firearm.
for a lawful
Prohibition,
purpose.
They had a lawful purpose
Right.
to be in possession of it.
Right, so I'm saying defending his family because the father is down, but he now picks up the gun and shoots the intruder. He's not charged with anything. He's free. This is a defense again for him.
Well, I don't know if the
Charge-
father giving it to the
Sorry.
son. I don't know if a father giving the weapon to his son makes the son's possession of the weapon lawful.
That is what I'm
will
confused about.
turn on several things.
Yes.
Yeah,
From where I am, Chairman, in the circumstance,
he would not
it
be not be
not
found
be charged.
guilty. He
No,
would
not
be charged,
guilty.
no.
Not be charged.
Okay.
Because once he's charged, he know, no, it can be what I'm saying. I'm arguing what it ought not to be. So
So if he's
even-
charged, he's not guilty. He's found not guilty still.
No, I'm saying that in those circumstances, in the first instance, he ought not to be charged.
But
Right?
if he's charged, he can,
Ah,
I don't think he can remove that.
so that's a backup.
Yeah.
Okay. So when he goes to court and the police now,
Makes
you
it
see the
clear.
thing about it, you see, what really bothers me, Chairman, is John Brown is dragged through the court system. Hold on 1 second there. This matter is tied up in the court for 2 years, 3 years, and he has this charge against him. I believe that the clerk of courts are lawyers, right? And the lawyer should be the clerk of court or the prosecutor who sees of this provision shouldn't throw it out from there.
That's not how it works, Member Jackson. Suppose a person,
Well,
I give you an example.
I'm going to ask the lawyer to come in. I add to that, Mr. Jackson, as a layman. What I see happening there is that the person is even charged because the police use discretion. What you'd get immediate, if he doesn't get bail, the lawyer go to court and get it for him same time, so he'll be locked away for 6 months waiting on this thing. And no, the time for trial, I don't know. But,
Well,
so the thing
but let me give you an example. If a person went on to a property, he didn't have, let us say he didn't have, or at the time the police came, they could not find a weapon. Two persons. And the other person who survived the shooting, or when I say survived, one of them shot and injured. And his story to the police is that I was not coming onto the property with the purpose of doing anything illegal. I may have entered onto the wrong property by mistake, and he got shot and injured. that is his story to the police. So the police takes his statement, and then the police doesn't have anything else save and except that this other person is saying, well, you are breaking into my house. So, yes, the son says he was breaking it. And the other person says, the complainant says he wasn't. So the person is charged. He goes to, the son is charged. So the son goes to court and says, no, but, so this is my defense. And then it's a matter of the court hearing it, and it becomes a situation where his illegal possession goes, everything goes.
Clause has to remain there because there has to be an out. And I said, bear in mind, this is a prohibited weapon section. So if the man is found guilty, it's 15 years in where the court for. So there has to be out for people who are in these kind of gray area. And it is the lawyers who will have to work those system and the court system working that way. I think we're getting there gradually. It's the end of the prohibited weapon section. Now this section is where we go to the Firearm Licensing Authority and those who are licensed. And we have to now examine this carefully to ensure we don't put undue burden on the sky. You know, I think I've seen it at the records office, you know, my colleagues, and the published picture really concerned me a lot. The records office is one of the more, it's crowded, we're going to fix it, you know. But the three people who, as you're saying, it's a real horrible thing down there. But the three people who I spoke to, really for me it was a bit of an eye-opener. One is a taxi man, and you can see a real solid honest guy in the mid-50s, not a hustler or anything, a mature fellow who is doing his job, come to get his CRO. The other lady is a early childhood education individual, and she's a big one, she may be near 60. I have no interest. I mean, for her, anything untoward to her child, you can sense her demeanor and everything, and the other lady is like a senior office help at a bank. So he cleans the bank manager's office and take coffee and tea. And the three of them is standing in line for 3 hours to get renewed, and they have to do it every year. That is really, you know, kind of taking the legal too far. We have to find an easier way to give them their thing. They have to come and go through the process. It's rough. As opposed to the man who is a... Now, what I wouldn't encourage the workers out there up and down in Canada, but you take a lady who works in a bank manager's office as a helper, as an office attendant. She has to go down there and spend 6 hours every year getting this thing. Kind of, we'll find an easier way. But I must say, this is the difference between a criminal versus an honest person who require clearance. We're on the section phase now, Firearm Licensing Authority, establishment of a Firearm Licensing Authority. Part 3, 20, 1, 2, 3, there's an amendment. The authority shall be responsible for regulating in accordance with this act. And we have deleted licensing, handling of firearms and ammunition instead of licensing, and the importation and exportation of firearms. I think that was came up in our review. Reference to Firearm Licensing Authority. There are no more changes. 25, 26. There's an addition under the same section 3, FGHI JK, causing in accordance with this act the marking of firearms and maintaining records in relation to such marking. All right, which then required to do. Continuing section 3, two, it's 31, no, this is 3L. No, what is that? No one. Captured person, the section 31.2. Oh, and this now is O. Added, maintaining records in respect of firearms, authorizations, and in respect of reports furnished by firearm dealers relating to the sale of firearms. I think that's part of the existing law. Is that it? They have to maintain a record of the firearm dealers' acquisition and sale.
Yes, that's in the current law.
And at P, so the O was inserted, and the O now, you have P as the last section of that, of 2 of Part 3. Board of Directors, third schedule, 21, nothing, no changes there. 27, 28. Make sure, 29. Oh, 28, sorry, yes, 28. Chief Executive Officer, Section 23, there's a change. Section C shall read, in particular, and the word shall remove, carry out the functions listed in Section 3. So the word shall is deleted. And I guess this is a stronger instruction. Page 29, delegation of function of Chief Executive Officer, Section 24, Item 1, we have a minor change. The Chief Executive Officer by or under this Act, or other than the power of delegation to such instead of employees, members of the staff of the authority as the Chief Executive. So employee is replaced by the term members of the staff. Page 30. It overlaps with 31 really. Section under funds of the authority. Section 3, Section 26, 3. The last line is changed from investment as may be approved by the minister with responsibility for finance, and responsible is changed to with responsibility. Essentially, this is indicating that when the Firearms Authority is investing their surplus, which ultimately may go to the consolidated fund, the Ministry of Finance should give approval.
Only if it got to the consolidated fund.
It's sometimes used by the authority, but with the approval of the Ministry of Finance.
But the Ministry and the Minister of Finance, by extension, as overall superintendents over the country's finances,
yeah,
including the stated, yes,
all surplus funds.
Yes. Even when it's used by them, not just when it comes to the consolidated.
That was a dispute recently by a particular authority, so yeah, so known. Part 4, restriction in respect of firearms and ammunition. I think this is declaration of firearms that may be imported or exported. The minister may, after consultation with the authority, the institute, that is, if I suspect that's the IFSLM, Mr. Richards?
That's correct.
Institute is
IFSLM, yes.
The Forensic Institute.
Yes.
And the Commissioner of Police. It's in the interpretation. So institute is added. By order of publishing, you got to declare the type and caliber of firearms that may be imported there. That's an addition, nothing more on page. Yeah?
I'm a little bit not so clear. Mr. Richards, the minister may, after consultation with the authority.
The Institute and the Commissioner of Police.
Okay, so that is deleted. The and the Institute is deleted.
It's added.
No, it's added.
It's added.
It wasn't there before. But the Forensic Institute now keeps a record of firearms as well, and ballistic database. 32, continuation of control system and the marking of firearms. We have no change at the top. Section 29, marking of firearms. A firearm imported into exported from, transited or transshipped through or manufactured in Jamaica shall bear the mark of the manufacturer and the mark identified in respect of that. So the mark of the manufacturer is added here. It's not deleted. Not necessarily, no. Yeah. 33. In the margins, I see removal, alteration, addition, or modification. No. Removal, alteration is change, addition, modification is substituted. Am I right?
Yes, that's just editorial to be consistent with the actual substance of the provision.
Thank you. All right, we proceed, page 34. Not doing badly. Section 2 of that section, in addition, some changes and an addition. In fact, 2 additions, 3 additions. The addition or modification of a mark on a firearm, A, may be done, not shall. Shall may be done. No, how this read now? To correct evident errors in the mark of the firearm, and shall only be made by 1, an authorized officer, and this is an addition, or a gunsmith at the direction of the authority, and the authority shall forthwith notify the registrar of the addition or modification, as the case may be. And the registrar is the institute. Mr. Richards?
Yes,
the registrar is the institute.
Yes, that's correct.
Right. Okay. And then 2, an unauthorized officer, direction of the director, an authorized officer, sorry, at the direction of the board of director of the institute. Or B, may only is deleted in the case of a firearm recovered by the police in the course of an investigation, may with the authorization of the Commissioner of Police be made for evidentiary purposes by a constable acting in the course of his duties, and the Commissioner shall forthwith notify the registrar of the addition or modification. Deleted is section 1 of the original B, which is be made by an authorized officer or gunsmith and the direction of the authority, and the authority shall forthwith notify the registrar. That is deleted. So too is 2, all the way to 3. So that I assume section 1, 2, and 2B replaces that section. 3 now is where the registrar receives, and no changes. So read it carefully and make sure you're comfortable. 3, there's a change in the last line of section 3. The registrar shall make such a correction to the information recorded in the registry pursuant to section 29, not the registrar. And that's more editorial, right? Okay. 35, 36. That's there, 37. Importing a firearm that does not bear the required mark, 34. What does this cover now? Is that deletion? A person commits an offense if that person imports. Is this an addition, Mr. Richards, or a deletion?
That's
34.
the original wording.
That's the original
there was
wording.
some discussion before the committee about the ambit of the provision, but no final decision had been made about retaining it as it is.
Well, if it doesn't have a mark on it, the person imports a firearm does not bear the mark required under section 29, then the firearms authority would retain it because it would be an illegal weapon.
Yes, Chair, I think the issue was whether or not that should be an offense, because
I don't think you could make it an
doing the
offense.
importing could hardly be held responsible for the,
So I'm saying it
the
wouldn't be an
firearm
offense.
not complying.
So I would make it an offense, it would be detained by the firearms authority.
Yes, I think that was the discussion that took place,
So
as I recall.
What we have done was to change the offenses to say in default of not paying the penalty, paying the fine, then the term of imprisonment should apply. So it becomes an in default of payment, of not paying the fine.
I mean,
So the truth is that an importer really should ensure, an importer being a dealer, really should ensure that the firearms that they get have the requisite markings.
I wonder if this is more the time sensitive. If they have it now and it wasn't there, you'd have to just get the affiliate to mark it and.
Chair,
Sure.
I'm
Because-
sorry. How would an importer,
Yeah, they
after
can't-
his best efforts, be able to guarantee that it appears here at this port with the correct marking? With his
Senator,
best efforts.
You're correct. The line is correct. Because the record, the application should have all of those data. So if it comes through the system, it is the importer makes the application should have all, it is checked before he's given the permit to bring it in. So he's not committing any offense. It will be error by somebody.
Yes, but Mr. Richards, as I'm understanding him to be suggesting, is now going to assign a term of imprisonment where there's a fine to be paid and he doesn't pay
No,
it?
that can't be. I'll have to find out what you're saying, because it would have to be that the weapon is seized by FLA, but they can't have an imprisonment for the importer. If he is importing it illegally, that's a different activity. That's trafficking. But if he brings a firearm that came through the system without the proper marking and he had all the genuine documentation, he couldn't be wrong. All the firearms that can say, well, and the rose made and I will detain the firearm because it's not properly marked.
And not only that, Chair, he would have paid for a consignment of goods that have arrived, and so he's lost some money there. That importer now has to take recourse against the manufacturer who has sent that unmarked weapon.
If the
So he's in a world of hurt.
If the marks are incorrect,
Yes.
he also holds the supplier accountable. The Firearms Authority couldn't release the firearms to him. But his...
Chair, I think if you're going to impose a sanction, the sanction should be for not promptly taking that, firearm
the
to
process,
the authority.
No, when the process, when the firearms comes in, they have to be checked by the FLA before they go to the store.
Well, so then they really ought not to be...
So he has no really...
Yes.
You can't hold him accountable, therefore.
Yeah, I don't agree, Ron.
That's what I'm saying. The penalty would be that the FLA, if the markings is not the correct marking, could detain the firearm. That's the penalty you'd have there. And he can then find his supplier, right, to get the right documentation. Once it's coming in, this could be, so there, in the schedule, there's an imprisonment, there's a fine for this, Mr. Richards? Is this classified as an offense in the schedule?
It's a fine and in default of payment.
No, I think you'd have to just put the Firearms Authority to be required to detain the firearm till you get the correct mark firearm. You can't fine him for it. There's too much processes, because remember, he applies, we verify the application is valid and that the data on it is there. Give him permission to bring the firearm, and when it comes in, he still has to take it through the FLA to review. Am I right, Mr.? Right? And what FLA does is to examine that the firearm that he brings in corresponds with with the permit he got, and then they mark it with our marking now. If the data on the firearm is not the same one that was in the importation permit, then the firearm is not an error. It's not an offense. It's just that the firearms will be detained by the Firearms Authority. Because you couldn't have determined what the guy is selling. If it goes through the process properly, it's the FLA have to detain the firearm until they get the correct ones, which may mean an investigation to the very importer, or the person supplying the firearm may not be as legitimate as he appeared in the first case. So that's where the offense would be. So it would initiate some investigation, because the FLA would have to report that to the ATF board to see who is the supplier of these irregularly marked firearms, because that's the man who is committing a crime. No, in the United States it may not be, but technically that's what it is. Thank for the notice, but we'll have to make sure that's in there, Mr. Richards. So the charges. The importer can be charged. You'll have to, FLA have to detain on what is essentially on a firearm that is not properly marked. It remains in the possession of the FLA. You couldn't hold the dealer for that. He did everything right. Try to say we move on.
Mr. Chairman, I just have a query. We have been seeing, at least in St. James Court, several persons who are visitors.
Yes.
Coming to Jamaica. And it seems that they pass through their airports abroad, and they pass through our airport on landing. And it is when they are actually going out, where a more detailed search is effected, that these persons are found to be in possession of either a weapon or ammunition. I'm just curious, Mr. Richards. Those persons would fall where? Into the 15-year category?
Not if they have an authorization to be in possession of whatever it is that they have. In their jurisdiction.
Pardon me?
In their jurisdiction.
In their jurisdiction,
right.
If they have one, but they have nothing here, where do they fall? Under this? They come under.
Once they have, they bring it from their jurisdiction.
Okay.
But you do have a challenge, David, and I'm glad you bring it up, Senator, because remember in the on the federal law, the states determine it's a right to bear a firearm, and the regulations come on the states. So you have a state like Texas where they don't need any permit. They need no permit. They travel around the firearm for any kind of weapon. So when he comes here by aero, he will not have a permit, except it is residential status in Texas.
Sorry. So, Mr. Richards, that situation is found on it is in this bill?
So
go ahead.
There's a requirement for a traveler to declare.
That is the 35.
35.
All right, but listen to the scenario. The scenario is this, that the person come, because when foreigners come here, they tend not to go through a detailed search as a local. That's what I see at our ports of entry. Right. So it is generally found when they are on their way out that the ammunition or the weapon, in recent cases that we have had in St. James, is discovered. So how 35 is drafted? 35 says every traveler who disembarks in Jamaica shall make a declaration in a prescribed form to the Commissioner of Customs stating whether he has in his possession, etc., etc. And if he breaches it, that's the offense. But where he's found is not coming in, he's going out. So how would this capture, 35 capture a scenario like that? Because you don't know then, except for his comments, where it is that he would have come into possession. So I'm just trying to find out how would they be treated? You follow what I'm saying?
Yes, I understand what you're saying, and I think I know the case that you're referring to. Unfortunately, it is unauthorized possession because you'd have come in as a traveler without the clearance. That's one offense that
it was attached to the crane that looked like a weapon.
Right.
The two things were attached.
To export, you also need an export permit. So it's
on this section, Mr. Richard, we are dealing with Mr. Senator brought an example which has happened. And there are two. The firearm that's going on, the lawyer will take out her firearm that she had registered in the States to carry. That's an easy one.
That I suppose is easy.
That's easy, but a single bullet,
yes,
which is much less offensive, but found on the way out. And it may be coming from a state in which he does not need any permit. In fact, hunting in several states, Colorado, Texas, those places, they need no permit to carry it.
Still unauthorized possession in our jurisdiction, sir.
Eh?
Still unauthorized possession in our jurisdiction.
Right, so they fall under the...
What are we saying that if they have a registration in their jurisdiction, they are treated under this section of the law, which gives them a lot of flexibility. In other words, they will take them to court and once they accept, they pay a fine and go home. How do you treat the one who's come from a very conservative state that allows firearms? That is a relevant question. A jurisdiction that allows them to bear arms without registration, carry ammunition without documentation, and he's now leaving the country. Does he go on the prohibited weapon or that? He has kept locked up for 15 years. How can we differentiate that? Because technically, we are encouraging him to come here. SG, guide me.
I'm not sure I'm answering that question, but just to go back to Member Sinclair about the fact that this does not address a traveler who is departing from Jamaica. I think that was the issue.
Yeah.
No,
it's not so much the person who is leaving.
It's just that we see a lot of, we have seen in St. James.
I know, when the person is leaving, you can
that is when they are actually discovered, and they are discovered with, primarily I've only seen one case with
I
firearm.
understand. Right, I understand.
And firearm can easily be established because they can show that they have a permit in the United States. So then if they were to be charged, they could be charged under 35, because if they had a permit, obviously they got it there. They just failed to declare it or to comply with themselves coming in. So they can be charged under 35, right?
So I just wanted to just point out, though, not that it... So this is true. This is limited. This is only dealing with persons entering Jamaica and not leaving. But I think it perhaps is also tied to our system. We don't declare when we're leaving Jamaica. We do a declaration for money, for different things when we're entering, but we no longer do that when we're departing.
Yeah.
So I'm just pointing out now, if you expand this provision, which you could, it means you'll have to put in another process for a declaration process when we're departing Jamaica.
No, well, I wasn't going there.
Okay.
I was just saying that most of them are discovered going out, but it can be easily determined. For example, if a person has a permit in the United States for firearm A, and they are found in Jamaica going out with firearm A, obviously they came in with firearm A, so they would have breached 35.
I see what you mean, so that you could use that to say that they would have traveled in with it, except perhaps that might be difficult to prove, though.
Well,
so, but the issue would be, I think you would be able to catch them under another offense.
But then I'm just asking, because we have had several visitors who may be found in possession of ammunition. Ammunition does not have a serial number on it that you could say, well, it may have been bought at this particular place in the States without the required permit. So for the person found in possession of ammunition going out as a visitor, is it that they are going to be charged under the prohibited section?
So that's where I'm thinking. Remember, I don't practice criminal law, but from my perspective, they would be charged under another offense, and I would think it's being in possession of a prohibited weapon.
I see.
And not so much this, because it may be, you see, if it is like a weapon that you can trace a serial number and so on, perhaps you could be able to try and make a link to say that they must have entered with it to be leaving with it. But there, as you point out, ammunition, for instance, you may not have anything to be able to
That's
identify.
exactly where we're at there.
And
Yes,
in any case, it may be very difficult for the prosecutor to really make the case, but it would certainly be available to the prosecutor to charge the person being in possession of a prohibited weapon.
Well, it would be good then that we say to the various embassies and so forth that
No, but you have to still provide some level of leverage here because in terms of the ones that are marked is either the laws provide for if it is registered in another jurisdiction, no problem. And most of the firearms are registered even they're in very conservative states or we say liberal gun laws. The person buying the firearm, there's a record of them buying the firearm. It's the ammunition that poses the problem because ammunition are not, in the conservatives, you just buy what you want and carry it around. How do we deal with that particular situation? Because that's what would happen in the extant case. I said a family which uses gun a lot, a child sticks a bullet in his crayon box and carry it out and going back with it and you find it. How do you treat that? Because, and as it stands now, you have to treat them as a prohibited weapon.
So isn't it also a matter of discretion for the prosecutor or the police to charge? Meaning you discover the article and you're going to, I don't want to use the word interrogate, but you're going to clearly,
there's a discretion
the persons
there.
will be detained and they are going to be questioned. And I would, perhaps this is not going to be palatable for many people, but it is still a matter of a discretion whether a charge is laid or not.
Discretion is what is called the problem right now. And you see, because if you go under the prohibited arm, the person could still get through the court. A minor, but you have to, if you charge prohibited, you'd have to go circuit court, which means the lawyer could go there and you'd have to get the judge to write there what you got the appeal to write the document to send to the appeal court. It's a long process. So if you allow them out and bail, it's an expensive and long process for a single round coming from a jurisdiction that allows it. Unless you're going to put ammunition, unmarked weapons, but that could create some problem. Well, if they're coming in, you stop them. But if they're coming from a jurisdiction where it is allowed, the clause dealing with jurisdiction would have to be written in such a way that you can take consideration of ammunition going out. What section deal with it, Mr. Richard? Where in the schedule you deal with that? With section 35, section 34. 34 and 35 rather. What part of the schedule lays out the penalty for that so we can get a sight of what it implies.
130.
One what?
130.
130. You see, what the SGS said is correct. In a perfect world, discretion is what would matter. But in our world, discretion is what caused the problem. Am I right, Senator?
Yeah, and another query I want to make, even using 35. Suppose if a Jamaican resident, because I can see a Jamaican resident being classified as a traveler, right? Based on the definition. And he says, well, I'm going to try and he comes in with a firearm. Well, I suppose again it comes to whether it is registered or not. What? if his firearm is registered abroad, he comes under this. If he comes through, gets through, because he uses and he joins what do you call it, a non-resident line, but he may have some dual citizenship type act. Yeah. You don't have a problem.
The problem is, if he is not registered, he now on summary conviction before a parish court, a fine not exceeding $2 million or imprisonment for a term of not exceeding 2 years. So it's a, but this is for the, this is not declaring the registered firearm, which is an offense. The one who comes in and is without declaring and was not detected and now going back out. See, we had a case recently where the gentleman left the island with a firearm. He's a Jamaican citizen. It was not picked up at the airport. Here, he went overseas, nobody checks that. He has a firearm for a year overseas, and he doesn't know how to bring it back in and renew his license. And I can't find the law how he does that. Ms. Wade, can you hear the legal reform? But can you tell me, how do we qualify this? He came in, he came through the system, he's now going out, and he's identified with 2 rounds of ammunition. All you have for him is that he's from maybe a junior woman or anybody, but he or she or child is from a jurisdiction that allows its liberal use of
Chair, it doesn't matter which jurisdiction. The requirement is that whatever you possess, you must declare on entry.
No, we take that.
Yeah.
That is no, he's leaving. He was not detected and entering, and he didn't know he have it.
But he would already have breached that.
Yeah, well, he didn't.
He's already committed an offense.
No, he has come in. He doesn't know he has a firearm.
Yes, sir.
Well, the firearm is easy to track because of the registration. He has a single round left in his pocket. He comes through, is in his carry-on case, wherever it is, a single round. He's been out. It wasn't seen coming in. He passed through the firearm. He's now going back out. It's detected. How does he establish that he brought in that firearm and therefore is in possession of it inadvertently? Their discretion, no. But discretion is what creates the problem.
Where is the discretion?
May I ask a question, Minister, just in terms of considering if this were not a firearm, there might be a jurisdiction where, for example, marijuana is legal. How do you treat somebody going out with marijuana? I just want us to contextualize it because we're treating the firearm as if it's not something which is which should really be thought of in a different way.
It's still relevant, but if you're going to charge him $5,000 for possession of, well, the ounce of ganja in Jamaica is not illegal, up to 3 ounces or whatever it is. But even if it was 5 ounces, you're going to make a fine. You're going to lock up the man for 2 years, or a child for 2 years, because he was at the range before he came on his holiday, and nobody detected this firearm coming in.
Well, the penalty here is $2 million, or $2 million, yeah. $2 million
2 years.
Or 2 years imprisonment.
Yes, but
and it's not exceeding. So I just want us to really think very carefully about the kind of message
I know, but I'm
want to be
saying
sending.
there has to be a distinction because a Jamaican, all right, young man goes away and skeet shooting, all right, and he is coming in. He has 1 round left in his knapsack, which he doesn't know is there. He can't know.
A A lot of drug runners will have the same excuse.
No. You see, I would think two ways, you know. We have come to the prohibited weapons. The object of these two sections of the law is to separate the criminal from the citizen, law-abiding citizen, who may in fact breach. Now, I can't, for the law-abiding citizens who end up with one round, I can't send to prison for 2 years.
We also have to hold them to a high standard, though, Minister, to be fair. And the penalty provision is not exceeding. So I think that each case should really turn on its own merit and let the person make their case to the court.
I can see where I said somebody could abuse it. But in any case, the risk is not taking, the threat we face is not taking ammunition out of Jamaica, you know. It's bring it in. And therefore, if you come to the airport and find it with 5, 6 rounds, 10 rounds, illegitimate, even 1 round, once they declare it, you know, we're getting there, we have to search for what coming in there, because the man leaving with a round or 2 rounds cannot be charged like that. As a citizen, a family who comes on holiday, the man's in, well, I don't want to use the practical example, but they're coming out of a conservative state. They use gun every day for hunting, whatever it is. And I said he has 1 round left. I mean, I go to the range and I put a round in my pocket and I forget it there. That cannot be charged as the same way you treat a prohibited weapon.
Sorry,
Long
Chair.
after I find I walk into a metal detector and say, heck, there was a round in my pocket. I went shooting, practicing target shooting, to go get my license. And 1 round is left there. That cannot be charged the same way. SG?
Sorry, Chair, just to make a very minor comment on the rationale. So you're correct that the main rationale of the government with the firearms policy is dealing with weapons coming in and how they're dealt with in Jamaica. But we do have international obligations, which is the reason we would be dealing with exportation. So I'm just saying there is a basis and a rationale
there's a basis
also for that.
But
so
those also have some pretty strong protocol, which is why we have to give permission for export. But he's not caught exporting. He is going through the normal travel with a single item. He's not packaging 1,000 rounds from South America to slip into Bermuda, which is now where our Cayman. He's going back to the United States, which is where he's quite legitimate to have 2 or 3 rounds on him. And it is clear it's in his possession, he accepts it, and he's a legitimate law-abiding. You can't charge him 2 years, put him in 2 years prison for that. It happens to anybody.
But Chair, remember that the judicial discretion will be exercised in that situation. And if there are extenuating circumstances, that person will not become...
Well, my problem here is discretion of the police and judiciary, because I don't know if it's exercised all the time in the best interest of the wider society. I don't know, man, just lock up a man for 2 years because come here from America and don't like him.
Well, I don't know that the law is not written in a way for the police to exercise discretion.
Sure.
You have to take the person before the court.
Mr. Chair, I was saying to my colleague next to me, I listened to the rationale, the reasons expounded particularly by Mr. Richards about the sentencing. Raise it to a higher standard. Put it to 2 years and let the facts determined by the court if it goes up to 2 years, if at all. And that sounds so reasonable and rational. But I wonder why it is limited. The rationale is limited there and doesn't apply to other sections, which we have already discussed, like Section 8. Why is the court shackled from exercising the discretion in the sentencing, as we are not permitting the shackling to take place in this event? Is that inconsistency bothers me terribly. And being persons, men and women of reason, I just pray that consistency and
No,
rationale, as potent as put forward
hear
by
what you're
Mr.
saying.
Richards, will
Member.
become not exceptional but pervasive.
I hear your comment, Minister, but remember we're not going that route. Yeah, but that pass is going to be appropriate.
My thoughts with my colleagues here, Chairman.
Prohibited weapons.
Just sharing my thoughts.
We are separate the criminals, and there is no apology, no consideration. A known criminal, when found guilty, must go court with a gun for whatever time he has left to breathe. Right? That's my position, and we have been elected to do so. Yeah, no. What I'm saying, that is what has given us the room to ensure that those who are not so can be clearly seen, not so inclined, cannot be treated the same way. And we have to find some way of, you see, there has to be some, I said it's, the discretion of the court is what? Yes. I mean, so far it has, in this case, they have been all, I suspect they have all gone the way of the discretion positively. But it still look a little bit. Mr. Richard, what I'd like to say is for 35 for the outgoing traveler, just make a note. I will see if we can do something to protect the average Joe who just happens to be rushing to the airport. That's what it is. Whether it's a visitor or a Jamaican who is in the circumstances, I said, just rushing to the airport. Whether it's a Jamaican visitor, Jamaican citizen visiting, or Jamaican citizen leaving, or a tourist who we invite here leaving, and he ends up having inadvertently a round in his knapsack, travel kit, night kit, whatever it is not reasonable. Well, the maximum is that.
Or you know what is the alternative to that, Mr. Chairman?
Yeah.
The alternative is just really education and insisting upon everybody complying. As Mr. Richards is saying, it's going to be difficult in my mind. I just raised it because of things that we have been seeing, but I think
yes,
we have to emphasize to persons who are coming here to Jamaica.
That has to be done as part of.
They have to be careful. Just as you have this, you go to the airport, did you pack your bags? Probably some other questions need to be asked. Are these bags shared with your other activities you're going to the range, etc., etc. But I think they have to be more responsible. And I want to side with Mr. Richards. I'm thinking that we are putting them in a very difficult position in trying to make a separation.
No, it's a new interrogation, Senator, because you see, it's not quite the prohibited alcohol would be coming like the Singaporean law, where if you bring drugs into Singapore, that traffic drug in Singapore, they kill you.
Yeah.
I say for a prohibited weapon into Jamaica, we're treating you for life. Now, when you come to the non-prohibited, there has to be a difference. And it's how we define it. What we're hearing is that this is becoming a marginal case where you're not sure whether you are. It's difficult to define. Because the single round in a child toy box can't be treated the same as a prohibited weapon. And it's how we define it. But that's what you're talking about. The advice to people coming to Jamaica must be there. In fact, I've spoken to the FLA already. And there must be clear distinction in education. You have to go put up a big sign at the airport. If you bring an illegal gun to the country, you can't go to the country, do it for life. Big and bold. But you have this gray area which has been abused, as we are aware, in Monty, which is the biggest entry point. Could you put a clause in there like you did for, where we did earlier, where we gave the escape clause that if you can show that this was inadvertently done, then it's a defense.
But Minister, you would have that defense when you present your case before the courts. I'm just, sorry, Minister, I don't want to detain you on this, and I know you have given a directive, but I just want you to really reconsider how it is that we're...
I'm changing it. I have a concern. I'm not there to change it. Look at it.
Yeah, because I'm just trying to see how we could, and it's not coming to my head exactly what we could do that's different here, apart from just leaving this discussion to the court to make that determination, or to the prosecution as to whether or not they want to move with a prosecution on this.
This is coming in anyway. Do you have regulations governing the person who is leaving with firearms? Well, no, there's nothing to say that. $36 is fine. 35. Well, the law. This law is even that is the one leaving the country that becomes a problem. So we can move on really. There's a section for export of firearms, right? Sir Judge?
For export, yes, for permits.
There are no changes suggested here. We'll leave it. It hasn't gone too badly up to now. We hope we get the right person. Continue onwards. 37, 38, there are no changes. 39. 38? I don't see any changes there. 39, section 38. Page 39, section 38 has restriction on the manufacture of firearms and ammunition. No person shall, and delete manufacture in the firearms and ammunition and put except under and account of the firearms manufacturer license granted under Part 5, manufacture any firearms or ammunition or possess a device with the intent to manufacture or any firearms or ammunition. That has been discussed and debated, and the better way to put it. Section 39, restriction testing, has deleted for another person. Page 40, let me say to my colleagues now, I understand there no attempt was, lunch was not offered to us today. I get they thought to revert it as well. So we'll have to break pretty early for, what you suggest, 1:30 for lunch? We close because there's no lunch available here. Two? All right. Oh, they're meeting. No, they start. No, we're breaking. There's nothing at 2. All right. It's that we don't have the lunch. We have to. Can we last until 2? Yeah, no, when we finish at 2, we finish altogether. 1:30. Half an hour more. We have come this far. Page 40, 20 or more rounds of section restriction dealing. Without the appropriate firearm authorization is added. This is pretty straightforward as well as section 5, have some more addition. Section 6. No person shall, and delete is acquiring the firearm or transferring the firearm or ammunition to, or accept the transfer of any firearm or ammunition from an individual whom the person knows or has reasonable cause to believe to be under the age of 21 years. Deleted a sentence and replacing it, firearm users permit granted to that individual. You seeing it? I think we had agreed to that. Page 40. 41, unless the person, nothing on 41. 42, 43, on the restriction and modification of firearm, deleted by Gunsmith. Section 2, the holder of Gunsmith license shall, and deleted as soon as possible, replaced with as shall forthwith enter in the records kept by the holder to person under Section 76. Forthwith was the operative term. 43, on the Section 45, unauthorized possession of firearm or ammunition. 45.3 seem to have been deleted. No replacement, Mr. Richards. 45.3 is deleted, and 4 is also, and 4 amendments. 3 were deleted totally, and 4 now reads, for the avoidance of doubt where any firearm or ammunition is carried in parts by 2 or more persons in the company like that. That's 4. 4 is amended. 4 of Section 45. Section 46. 46D. The following change is done. The person in Section 1, the person is 1, the personal representative of any estate of any deceased person who, or the trustee in bankruptcy. So the executor or administrator is deleted and personal representative brought in, replacing. Page 48, Section 47, restriction on kind of firearm or ammunition in a public space. 2 is 3 is an addition. Where a person is unable to produce the appropriate firearm authorization when so required under subsection 1, but is able to satisfy a constable as to the person's name, address, and identity, and A, the constable shall permit the person to produce the firearm authorization within 24 hours thereafter at such police station may be specified by the person at the time when the firearm authorization was required to be produced under subsection 1. And B, if the firearm authorization is produced pursuant to paragraph A, the person shall not be convicted of any offense under subsection 2.
Chair, can I just ask for clarification?
Go ahead.
Who specifies? It says at the police station as may be specified by the person? Or
Which I suspect the intention is said the nearest police station to his home.
so the intent is for the person to be able to tell the police which station they want to take the firearm to. I just want to, this says at such police station as may be specified by the person at the time. So it's up to the, sorry, I'm not following. That's maybe.
No, remember this was patterned off of the provision in the Road Traffic Act. So it's
right.
civil,
So it is
but
that
it's
the person
policy
would
whether
be,
the person
okay.
should specify.
Okay.
As this are coming to being, I can see the concern, understand, but I'm hoping that by the time this act is, by next year at least, not even before this, not when this act comes, I hope this will be operational this year, but by in a short while, the level of communication between police stations will allow them, the officer who is apprehending can in fact communicate with all the police stations.
Right, so that is the issue, because I am a constable in Clarendon,
right.
and I'm going to tell that constable, look, I am going to take it to Elton Road Police Station tomorrow.
Yeah.
It means then that this constable...
There must be communication.
So,
Ellison would expect that John Brown is coming to the station with a firearm.
You realize that there can be a gap, though. There can be a...
I stay with it because I said I expect that communication to be in place by then.
Well,
Chairman, I have a broader concern in relation to how the provision is written, because I think there's a loophole here for persons who may not be legitimate holders of firearm license to get away, for want of a better word. So we're now allowing the person stopped by a constable 24 hours to take an authorization to a police station of their choice. There's nothing here about the firearm being detained, the person being detained until they produce the authorization. I thought the discussion in the committee, to my recollection, was that there should be allowance for the firearm to be detained by the constable until the authorization can be produced, but not just the firearm, but also the person. Because what may happen is that somebody may steal my firearm, stopped by the constable, I cannot produce the firearm, and he says, okay, well, give me the 24 hours. 24 hours, I don't come back with neither the firearm nor the authorization. There's a huge loophole for persons.
I see the loophole, and there's a question whether we should, as I said, block it by the way I've said, but bear in mind section paragraph 3 says where the person is unable to produce the appropriate firearm authorization when so required under subsection but is able to satisfy the constable as to his name, address, identity, enough information to verify that he's of some. Hold on. I'm going to, and we should. You could put a national ID as part of it because some people will not take the ID.
Mr. Chairman, Mr. Richards.
Hold it a little bit now.
Mr. Chairman.
On the system you have in place, the smart check give the policeman the facility to check those details that they are verifiable.
Mr. Chairman, isn't the address not on the national ID? I don't think
no, I just said add it to this.
I will say this. I am just totally against this section. I was against it when they brought it under the Road Traffic Act about you not traveling with your driver's license. And I will just show you something, Mr. Chairman. I have a key. This is my car key. And here's my driver's license. I can never go in my car without my driver's license. It's an easy item to have. And if I were to flip the other side, I won't tell you what is on it.
Your marriage license?
Yes, my marriage license is on it. I think that when we have persons who are adults who are expected to be responsible with motor vehicles that can be used as weapons, and then weapons that are weapons, this provision, I am saying, should not even be considered. If you have a firearm and you're going into a public place, you must always be responsible to have your permit with you and to be able to produce it. I think we're getting...
And I made the point as well, you cannot go to the airport without your passport and say, okay, can I go on the plane and bring my passport in 24 hours? No, you can't. And this is a firearm. This is a weapon that can kill people. If you are granted the privilege to have a firearm authorization, you must be so responsible to always... Taking up your firearm is a deliberate action. So you should not be taking up your firearm without also taking up your authorization.
I hear you very loud and clear, both my senator and who come from and you're Mr. Richards. And the idea of detaining the firearm until they produce the permit, I would go with. But I said, remember, the whole purpose of this bill is to separate the criminals from those who are honest, hardworking citizens. And part of in separating them is to begin to provide a certain quality of service to the honest citizen. Just like I go to the records office. I cannot, by next year, the lady at the financial institution must not be sitting down there for 4 hours from 5 o'clock in the morning to get a permit to go back to work when she had been there for the last 10 years. Her ID, her fingerprint, and everything about her is there. So I'm saying there has to be some room, as we do this, at the honest citizen who, in the context of our violent society, if it, depending on who is, in fact, may need to carry a firearm. And therefore, it must be rigid and sensible, but it must not be burdensome. And I agree that if he carries a firearm, he should seek to have his license, but it can happen. The inadvertent movement, him son at school in an accident.
And he takes up his firearm.
And him run out of he had his firearm in his waist, but his license was in his wallet at his desk. And him drive out without it. Without him driver's license too.
You remember the firearm though?
The firearm was on his body. The firearm was his body. And him jump in the car and him heading for the school.
Chairman, I hear you and I see
So
your
he
position.
didn't have to, Senator Sinclair did the right thing and put the key on the firearm, but not everybody went and put the key on it. He got him in a very safe place, and I was, he's at home, him get the phone call, you need it now. The child is, is hurt, is sick, need you immediately. Him jump in the car and gone, and then meet a policeman on the road. Look, the case, there has to be some leverage there for the citizen. And I said the service we give to them has to be different. And the move to have a level of communication and digitalization will provide that service. You can check the man, he should have him ID, he should have him address, him have a driver, like his car would tell him where he is, him address is correct and all of those. Then you can say, well, I'll keep the firearm for you until you get the license. But I can't charge him with an offense, man. I think that's going a little bit overboard. My view.
And Chairman, you have my full support on that.
Right?
Mitigating circumstances, sir.
Yeah, but I don't even have to go to court for it. No. If it has a firearm and you don't have a license, you detain it for till him bring him firearm license come. That I can. I
don't know, Mr. Chairman.
The policeman will stop must be at least a vehicle. If he came to the police station, him give him a receipt. Him can have a printer now, have a smart check in his hand, and can print a receipt, hand it to the owner. The seat here, come back. I am constable number 1, 2, 3, 4. But that from the Savannah police station. You bring a firearm license tomorrow. Whether you deliver it at Black River, you come back for your firearm. I can't charge him. So Richard, it's the purpose of this. And if we allow it to happen, we're going to end up with the people. We're getting knocked for or approach the licensed firearm holder. I mean, I don't want to travel up and down my firearm like that, and I always have a firearm license. But I think I have to give him some room. I'd go with adding that he'll have to keep his firearm until he returns his license. I wouldn't put 24. So the police station keeps it until he returns. I'll add that to it.
Even that, Minister, I think is also a loophole. I think if you will consider instead of...
The bad man who won't give it up like that and drive away and come back for it is not enough to penalize the other licensed citizens.
Minister, I've heard of instances where licensed firearm holders also have on their possession illegal firearms. So I'm just saying, we don't want to, as much as we want to have a regulated framework.
Instead of that, Mr. Richard, it's not significant enough for me to put a burden on the thousands of people who are honest and driving around with the firearm license. So it's a matter of proportionality.
I'm suggesting, Minister, because we had discussed it in the Joint Select as well.
But I would
for the firearm as well as a person to be detained until the firearm authorization can be produced.
No, the firearm can be detained, yes, not the person.
And what if, sorry, I have to belabor this point, Minister, because I feel very strongly about it. I know we've had this discussion back and forth.
The policy is that we separate the criminal from the other citizen.
Right, but what if the firearm, what if in detaining the firearm the person never comes back?
Then you keep the firearm. It's off the street. It's an illegal firearm. You have recovered a firearm, which we do regularly. If the man was taking an illegal firearm away, yes, maybe. But the few who do that, there are few, and in fact, the police have an ID on most of the others. If you have no ID, then you have another challenge. The police
Well,
can say it.
Mr. Chair, why, as I said, I'm reiterating my support for your point. Because where the man don't have the ID, the permit with him, the officer can, one, require him to provide any other form of ID to identify him to be who he is. Two, he can, as you said, detain
The firearm.
the firearm until some specified prescribed period that he provides.
In this firearm until he produces his license.
So, and let me ask you, Mr. Chairman, let me ask you this. A person has a driver's license that has an address. The person is in possession of a NITS card. The person is in possession of a firearm, but never had a permit. Police stops him and says, "Can I see your permit?" "Oh, I forgot it. But here is my, what? My name, my address." And we know that the address on the driver's license does not have to be his exact address at the moment. And the NITS card, I don't believe, is going to be carrying an address, if I recall the conversation. Pardon me? So the officer looks at it and says, "Yes, this looks legitimate. You can go and bring it back in 24 hours, bring your permit." Or even bring, and he takes the firearm. But when you check it out, the man don't turn up because it's illegal, it's a criminal.
Yeah. No, it goes beyond that in what we are trying to do.
Mr.
Senator,
Sir, let me
no,
just
what I'm
complete
saying,
my thought.
the
Mr.
officer
Chairman, let me just complete my thought.
Yeah.
And it takes me into another realm. You may say it is not analogous to the situation, but we're talking even about this. I always hear Jamaicans get up and we speak about our rights, this, our rights, that, our rights. Because the Charter of Rights has, but nobody wants to say you have a responsibility.
No.
You have a responsibility.
Yeah.
And you have a responsibility in many different areas. You have a responsibility as a Jamaican, and in this particular specific situation, you have a responsibility as a person who was given the privilege to hold a firearm, a weapon that can create mayhem. And then you are leaving it for a police officer. Okay, you have satisfied me. I have been able to convince you. I can probably, I'm not saying what the chairman is saying, I'm saying what this legislation is saying. The chairman is speaking, giving us examples. Okay, you have a nice, good person, and the person says to the officer, "Well, I am John Brown, etc., etc., and he's satisfied, and so he can go." No. And I don't think we should give that leeway in this legislation. I'm putting it on the record, Mr. Chairman.
And I
hear your position. I'm putting it on the record
think
that I am opposed to this provision in the legislation.
Your legal colleagues have taught me a concept in the Charter called lateral responsibility. They are looking into it, and I accept it with more than, I think I maybe use it more often than many of the colleagues who are dealing with the law. The SG will verify that for me. Many times discussing other legal matters and rights, and the need to have that responsibility embedded in our laws, that if you deny other people their freedom, you have a right to be denied yours until the person is free, the law abiding is free. But in this case, Senator, I am concerned that this, as I said, having separated the prohibited weapon as a criminal from the regulated firearm, I am also obligated to provide the citizen with a certain level of service that will not unduly inconvenience him. Now, I'm saying as we are moving now, can produce the various things to verify, but it's not that he produces address and name and identity, etc. My police officer will be able to verify those. If he can't verify it, different, you know. He can verify it in 10 seconds by going on his smart check, and he said, look, this driver's license is bogus. So immediately, I'm a criminal. This address is bogus. We can do that. Now, if him fail to have his smart check with him and him fail to have, it will be my failure, not his failure. So I'm supposed to be in a position to be able to verify this, and I say to him, I'm fine, but I'm still in a position because where the firearm is concerned, a dangerous weapon, you'll have to leave it with me, and I can send that information to the police until you bring the firearm license. That I agree with. Him can't carry it without the license.
And what I'm saying, sir, is that the person is able to satisfy the police by whatever means of his name and his address, but he has an illegal weapon. That's what I'm saying.
Yeah, whatever is illegal,
So,
I've recovered it. Because if everything else, first of all, if everything about him is all right, that his address is there, then I can find him and lock him up again.
Why? Sir,
if the other thing are verified, I lock him up.
Chairman,
Yeah.
I'm going to raise a case. The police knows where the house is in Carl Gardens. The police knows the person's name. Can they find him? Can he be found? The police have advertised it to the whole world. Can the person be found? Pardon me?
Yeah, but
the provision here doesn't provide for it.
No. What I'm saying, it should be added to it that once he doesn't have his license, the police take possession of the firearm until they bring the license one. But in the process of providing what this way show is able to satisfy the constable about his name, address, and identity. So, and whatever is there, that means the police officer must have a way of verifying that. Because while there is the odd case, I don't think it justifies inconveniencing all the other honest citizens.
But, Minister, if we have the person in our custody, we don't, well, on behalf of the JCF, I would say we would not support having the person leave to go and supposedly produce the authorization. There may be circumstances, as CTD has indicated, where this provision is a provision that we will now allow to be utilized by persons from the illicit regime.
How many of those exist?
At best, what this provision does, if I may, is merely an inconvenience, I would say, on persons within the licit regime. And if it is that they do in fact have an authorization, then all they need to do is to produce it.
No, you see, I give you the counter there. You're speaking well for it, but the law enforcement is that you're the police. You know, the same that applies is the host of people out there. The recent survey on police attitude that I think is as high as 70% of the people in the community. But I'll be corrected. But a high percent of people in the community trust their police. That is the police. They know around them.
Yes, that's
correct. On the other hand, when they ask about nationally, as they go two questions down, nobody wants to trust the police. You know why? Because there's a narrative out there that says every policeman is dishonest, right? And give breaks to criminals. It's a story. So the police they know, every police they know is good, but every police they don't know is bad. And it's proportionality. All I'm saying, that now that we have separated the criminal, because technically the police know the criminal, the gunman, that's the reality, 90% of them. I just fly through the police checkpoint like that. The proportionality, I don't think is justified to in any way lock down, inconvenience the honest citizen. Not by design, so much so, because of the 1 out of 1,000 who might be trying to slip through the checkpoint.
Chairman.
So I'm saying you take the firearm, which is the instrument of destruction, you detain it.
But what if this person has access to additional
If
firearms
not,
now?
one way you can find him, can have my address, and in time we'll find him. Once that doesn't come and put him on the wanted list, I'm find him. It may take him 6 months, it may take a year.
It may take years.
For the man who is that finger I'm going to dress up in a jacket and tie, that means a criminal who likes to enjoy the good life, you'll find him somewhere soon.
Chairman, isn't there required to be kept a database of these authorization holders?
Yeah.
So if in that case, would the police not be able then
That
to
too.
check? So if we
Yes.
put in the requirement, then in addition to being satisfied about the name, address, identity, if the police are also satisfied that the person is the holder of an authorization, it's just that they don't have it on them, then that would enable them then to permit the person to go and produce the authorization. So if we qualify it further by including that, that would narrow the category down a bit. Would that help?
Yeah, no, it is still, that's along the I'm saying, once he can satisfy the police officer, he gives adequate identity. In addition, he can also check that that identity has given him an address is the holder of a licensed firearm. He can still hold the firearm till he comes back. But he's verified he's a holder of a licensed firearm, he's a driver's license owner, he has a fixed address. He has everything about him. So there shouldn't be any chance, but we will take the firearm from you because that's the penalty. You have to understand that although you're an honest citizen, you can't drive around without your firearm license. So you take it from him. And if you want to ticket him as well, I'll ticket him, but I'm not going to put him to work. I can charge him $50,000 and go and bring the firearm license. Mr. Richards, I think there you go. Once he can verify that he is the bona fide who. No, Mr. Richards is thinking criminals. We're in this section that thinking honest citizen. Once you can verify he's the holder of a firearm license, his address, etc., but he doesn't have the license, he takes it away, keeps it until bring the firearm license, and fine him $50,000 if you wish.
So the police has access to the.
He have access to he has the ability to access those records.
That exists now, that the police has access to the FLA's database in respect to.
Currently what he has to do is send it to the central command, and the command call and get it.
All right.
It takes him maybe 15 minutes at most.
And I believe it is intended that in the future we will
order,
get direct access.
In another, I give it 9 months. He'll have it all. Currently he has to call the center.
All right. Well, I suppose that is,
and you can ticket
possible,
him.
but the person could be detained until that time.
The gun will be detained until he brings the firearm license, and you can find him.
No. If you put in the other
ticket.
If you put in, Mr. Chairman, if you put in what was suggested by Ms. Grant, and it can be checked on the FLA's database,
right,
then you don't actually need to see you wouldn't actually need to see the permit that he has, right?
No, this is where, Mr. Rizal, if the man end up giving the right address, right, that has the firearm with him, in order to hold up the man, that's where the criminal comes in. Then he could, in other words, the thing is, he's using the bona fide document he has stolen the bona fide document of a citizen. Then he'll be apprehended. So all this take with the illegal gun, and you'll have to chase him down after that because he had been a criminal. But you're not.
But with what CPC suggests, Chair, but with what CPC suggested, it would mean that the police would have a red flag to know that this person really don't have a license for the firearm and could detain.
No, this is the other license, so sense,
could detain the gentleman, the person immediately, and so the suggestion.
But if he has no license, there has to be some kind of holding to account.
Yes.
So either you hold the firearm for the 24 hours or whatever time he brings his license, because you know he has the license, but he was traveling without the license, or you ticket him. One of two things. I'm just saying there has been some accountability. I'm agreeing with sentencing that if a man is responsible, is given a firearm license, he must exercise a level of responsibility. But the fact that he has left it at home, I don't want to criminalize him. I still want to hold him accountable. So,
being detained,
lock up the man at jail for no reason. Jail or not place. I'm not going to make the jail so comfortable, but I don't want to go there right now. It take me a little while, money. Another place, I look up in the other citizens for a night. And still, for some time, they like to be crowded. my minister is doing all his best to make sure they are in all levels of human rights are acceded to and are in good order.
Which section are we moving to next now, Chairman?
All right? So, Mr. Richard, you will include in their positive ID, allow the police to identify whether he has a license or not. We have said with that what Mr. Jackson is saying, ticketing him or just take the gun for overnight. All right. That, Miss Grant, they're saying if he doesn't have the license, we keep the gun until they bring the license. Yeah. Fair enough. Section.
Background though, Madam Alcott had made the point about in respect to the having access to the CLA,
yes,
to the FLA
by the
database.
Attorney Alcott is a member of the police team. See, we have professional police.
I don't know why you think Madam Alcott needs any additional.
I know you want to speak to her, but I just want to assure that is a.
Well, I won't deny that.
Of the police force today.
I hope my colleagues can assist me here to protect me from the chairman. But the point you raise about the access to the FLA database, I think is very much valid, because you can instantly or within a short period establish if John Brown is a licensed firearm holder. The only issue that would arise, which would be any different than him having a permit, that he is who he purports to be, right? But the ID that he carries, that says John Brown, would have a picture on it that you take to be a bona fide copy and not a fraudulent copy of a permit to say he is who he proclaims to be. So once the officer is satisfied that by whatever means that John Brown is John Brown, the person standing before him is John Brown, then I think it negates the need to go any further, because one, you establish that John Brown is issued a permit and all the information in the permit can be ascertained right there and then. Two, you have established that the person standing before you is in fact John Brown through an acceptable other form of ID, for example, a passport or any other government-issued credible, and the NITS card, and any other thing to verify that he's, then the thing goes. Because the whole idea in having the ID, is to say you are who you are and you are permitted to have a permit. That's all the ID does.
Okay, well,
does give a permit for that firearm that you're carrying. So the permit is specific to the firearm.
Yes, but the access to the database gives all of that information.
Yes.
That would be carried on the permit that you
we have to be mindful of possibly opening up the floodgates now, because that would mean that holders now just would not be carrying their permits. So I still believe that we still need to uphold that aspect of it, where license holders are still required to carry.
But when you say floodgate, I'm a bit scared. What is the floodgate?
No, Minister, the principle of identification during the firearm is established. There's still accountability that they carry the firearm license.
Yes.
So what all Ms. Alcott is saying, that if you make it too easy, you can have, and we have to provide a high quality system. We make it, but they still hold them accountable. So you have to take the firearm from them or ticket them, or if not, if the picture comes up on their instrument with the firearm license that verify without doubt that it's the same person they have, and they're not thief the man, them thief all of it, you can do it. But bear in mind that if he doesn't have his license, the last loophole are closing really, and it's only been taking the gun, and if the man's a criminal, you go track him down after that. We are prepared to do it, because if you stole the man firearm, driver's license, all the other except the firearm license, then you could say that this is the same person. So as I said, the police must satisfy themselves that this is the same man with the same license, etc. If there's any doubt, he keeps the firearm until they bring the license.
May I also just point out, Chairman, that we have identified the specific police stations where firearms can be stored. So it's not any police station. So now
No,
we're
that's the
saying to the
storage they're
police.
referring to. No, that's the storage they're referring to, Mr. I'm not referring to storage. The database for the firearms, the authority has all the numbers and pictures of it that the license you get in your hand. Ultimately, the police command center can access that database from the command center. Ultimately, we'll be able to access it.
Understand, Minister. The point I
That's
was
all
trying
we
to
need.
make, the point I was trying to make is in respect of detention of the firearm. So now we're saying, so there are specific police stations where these firearms
No.
can be detained,
You-
retained.
You detain
So
for
we're-
24 hours in the motor police vehicle if you want to see for there until the man don't open 24 hours, you carry to the police station that is
So
locked
are
away
we then saying any police station?
for 24 hours, and if it does not come in the 24 hours, it goes in storage. Yes. Eh? Yeah, I know that. They have a lot of police stations that they have listed, yeah. No, but if he's up in Balaclava and he can't store it there, he have to carry it down to Santa Cruz the next day.
So based on the question that was asked by CTD, should the specification of the police station then be
No,
by the
what I'm saying,
constable rather
madam,
than the person?
The policeman, whatever happens, unless you're going to insist that the man carried to the specific police station with you, the police officer is detaining the firearm. He can detain it to take it to the police station. I give him 24 hours to get it there. The policeman in the patrol vehicle, I give him the right to detain the firearm, locked away with himself, and carry it to the police station. That's all I'm saying. I don't
To
want.
which police station?
Look,
To any police
what I'm
station?
trying to get at, Mr. Richard, that having separated the criminal from the honest citizen, I must provide the honest citizen with a decent service. And the police officer, I have to assume the police officer is competent and honest. Right? And if I do it below that, then I'm going in the other direction. That criminal. So I'm saying he can then detain that firearm. He will send it to the station, and yeah, I would be willing to say he can detain it for 24 hours. And if man doesn't show up in 24, then it go to one of these 40 stations that he should go. In other words, if he's in Balaclava, which I think doesn't have any storage except a small thing, him lock it in the Balaclava police safe, and if the man come back the next morning, get him gone. If him don't come the next morning, him drive it down to Santa Cruz and lock it away in the storage, which gives him more accountability. Right?
Given.
Yes, to produce a receipt. One or the other, emailed by some mechanism. I'm not against the rigidity. The framework must be rigid and accountability must be there. But once we get in this, leave it. Providing Jamaican citizens with a quality service is also part of our responsibility to the government. And to treat them, right? That's why I'm inclined to put in there, I still hold him accountable, 24 hours or fine him. Like a ticket. No, he must, I'm supposed to carry him on with him license. You can charge him $50,000. That's one note in a little short while. Do it again. All right, come. We're rapidly approaching 2 o'clock. We didn't move from page 40. Well, it's 1:30. Well, you finish. Hold on. When we say finish the section, requirement, whatever that is. We have finished page 48.
Sorry, DPM, I just needed to have clarification on the amendments. So the firearm could potentially be seized. I heard a member ask if a receipt would be given. I was just wondering if it would just be tied into the other provisions in the bill that deal with seizure.
That deals with?
Seizure. So that rather than having to replicate whatever the process should be.
You put in the schedule.
I don't know. So that's why I just want clarification on what the amendments, what has been agreed by the committee then. Let me put it that way.
I'd be advised by the technical team and what Ms. Grant suggested was that the CPC, that we just include the It should have clear identity. Once it can be verified that he has a license.
So let me perhaps explain the reason I'm asking for all of this, because seizure can then tie into forfeiture, because you also have to factor in that someone may not return for the firearm.
If he doesn't return, it's forfeited.
If he doesn't, right. So I'm saying
So,
that there is a scheme already in the law. So I just wanted to be clear on whether this would fall within that scheme.
Oh, I got
or
you
if we're
now.
doing something a little
I said,
different.
I'd have to advise by the...
And the one reason I asked, because I heard someone talk about a receipt. Because naturally the person, if it was me, I wouldn't be giving it up unless I get some sort of receipt or something from the officer. So I just wanted to understand a little better how
No,
it
I
would
understand.
tie in.
I'd have to advise or structure it, and I'll take advice from both your office and CPC to be guided by what. But there has to be, if there's forfeiture in there, then that could be put in there. I don't know. Or do you? Is it, this could end up like a 12-year-old versus a 16-year-old, you know. The man is good. Tell him, leave him like here. I'm trying to avoid. The amendment you suggested, CPC, was that you verify that he's a bona fide license holder and you release him. If not, detention would mean forfeiture, that's SG suggesting. So you'd have to put that amendment on the forfeiture section. Am I right, SG? Right. In case you don't turn up back for the firearm, for completeness. We'll therefore stop at, look, Mr. Jack, Senator pulled us on this one. We stop at 50, which is easier to remember. There's no change in section 49. I think 48 has a change, which is an addition. Deletion. Person shall conceal the firearm and shall not intentionally expose the firearm. Not at all times, except in circumstances set out in section that. So we can take 48 and 49 as amended, and we'll come back, we'll begin at section 50. All right, members, you know, I think we should do this review in person. When we do it online, we're going to end up with, it's going well, there's not a lot to change after this. Our next sitting is when? Tuesday? And we continue. Tuesday, we should be able to finish it. At 2? Okay. So you come to Parliament on Tuesday, Minister Jackson. You're a great parliamentarian. It's your platform. You look very comfortable there. You like it, so we'll have you here on Tuesday. We can't allow you to time. All your technical team in there approves, so not only the political people. So that the best, they respect your parliamentary. In fact, the younger ones here are trying to emulate you as a parliamentarian. And the technical team respect you, so they want to see you here on Tuesday at 2. They like to see you. All right, we adjourn until next Tuesday at 2 o'clock. We should be able to go through this family. So when we finish this process now, let me get back to the technicalities. Mr. Richards, you're my son not to call you at midnight on Sunday to tell me where we go from here. Right? I'll wake you up in the family. When we finish this process and all these means that the CPC takes it again, or do we have to come back here and what do we do? If once we accept all of this, we finish this part.
I would be refining these to send to the clerk, who would then attach it to the report. But the recommendation should include that the bill be retabled with these the changes as recommended.
Chair, given what CPC just said, isn't it also possible for us to just proceed with amendments that you move in the two houses, as opposed to pulling and retabling?
They're a bit substantive. It's going to be difficult to follow as a list.
So, now I'm just trying to get the steps in. I'm just, so I can kind of see how far I go. I tell my colleagues, I used to shove my technical that the passing a law is 39 steps, and he said the steps have 2-3 sections, and they get narrower and narrower, you'll fall down when you get there. So, once this is done, the report is done by Parliament, and that comes to us for approval, and then we send it to the House. Okay. So we have at least 2 more sittings if we go to the rest in, at most then. Now when you finish with this part, you get it to prepare the report, so we give you some time, and then we come to get it back to, okay, sound like we should be there now. Reasonable time. This act in place, too many characters out there. We just had a killer, one of the killers we just apprehended, was given 6 years for possession. Yes, and he came out and started killing again. 6 years for a gunman is actually a university training. So he graduates a better gunman from prison. No, we catch them, but they will sentence them. How much every day? The only time they get sentencing is when they catch them and then fight their way through and them do. Send them home. We adjourn until next Tuesday at 2 o'clock. Can someone so move? Thank you. Thank you for coming, technical team. You get your time to have